Good morning, Sona.
Good morning, Marianne.
How's it going?
I'm good. I'm just tired today.
Yeah, oh no.
How are you?
You better have a little cup of coffee or some tea.
Oh, yes, I'm about to pour me a big glass or big cup. I only have, I think it's 3 of them this morning.
Okay.
It's Child, Derek Jones, and Matthew.
All right, cool.
Okay, thank you.
Yep, thanks.
It is 8:30 by this court's clock. This docket starts at 8:30. We're just waiting, I think, for defense attorneys to appear. And I see Ms. Epps Ward trying to log on, Mr. Middleton, which means we can get going on your case momentarily. Are we having problems? So the gentleman in the car with the oxygen, yes, your name, please, sir?
Danny Hughart.
Thank you, sir. I see you at the 8:45 docket. Thank you, sir. Ms. Epps Ward, good morning to you.
Good morning, Judge. How are you?
I'm super. How are you?
Good. I have three
Did you-
cases before you today. I'm sorry, I was in the wrong courtroom.
No worries. Do you need to speak to Mr. Middleton?
Sure, if I could. I have him. And do you have my other two cases, Brandon Frierson and Donald Childs?
Yes, ma'am.
Okay, thank you.
They're moving you into, Wayne County already has him on, so they'll move you into a breakout room. The prosecutor's here. We're ready to go whenever you are.
Thank you.
You're welcome. Marianne, what dates are we using? How far out are we?
Just for state, we have next week,
No, I mean, exams, are we,
11/16.
I wonder if Judge Green has any. Nope, because next week, she'll probably put some on the rest of her dockets. Okay. I was wondering if she or Judge Oakley had space for exams. Not on the 12th, on the 19th. I hate to do that, but. So there was a story on the news last night about the Oakland County Sheriff and White Lake Police Department, maybe. They delivered this motorized car to this little boy that's going through treatment for leukemia. They had the sheriff's badge on the side. They delivered this little motorized car. Well, not little, but the size toddlers ride. They delivered it on a flatbed. They had the helicopter flying over. It's an unfortunate circumstance, but it was just a good showing of support for this family.
See, we need to hear good news like that, right?
Mm-hmm. He's 3 years old, I think it is. It was just a nice story. Good morning, Ms. Maishan.
Good morning, Your Honor. How are you this morning?
I'm wonderful. How are you?
Peachy, thank you for asking.
Do you need to speak to your client or the prosecutor?
All I need to know is if prosecution is desisting. It's my understanding that the complaining witness is deceased.
Your Honor, I have not been able to verify that information. I have reached out to my sources and I haven't been able to verify. Sorry.
This is 220, that's okay, 220-242 FY, State of Michigan versus Danny Rose Hughart.
Yes, ma'am.
Your appearances, please.
Good morning, Your Honor. Bryn Bailey on behalf of the people, P84009.
And good morning, Your Honor. May it please the court, Kim Michon, Neighborhood Defender Services, P59167, and it's my privilege to represent Mr. Hughart. Your Honor, we're here for a PCC. We were hoping that prosecution would be able to confirm if the complaining witness it remains with us, shall we say. It's my understanding that this took place quite some time ago. And obviously, the passing of the complaining witness is not linked to the case before you. whatever the court would prefer to do. Mr. Hughart, as you can see, has a myriad of health issues as well. I suspect it would be best for him not to be exposed to the courthouse. If the court would adjourn this matter one more time to see if we can confirm whether or not we have a complaining witness, we would appreciate it.
Not to be indelicate, but what is the difficulty in confirming whether or not the complainant is?
So, Your Honor, I have to go through and get an official record of either an ME report or a death certificate. I've made that request and haven't heard anything back yet.
Can I ask, Ms. Bailey, have we confirmed, well, when we say confirmed, do we know that the complaining witness is deceased and we're just simply waiting for paperwork to confirm?
No, I have not confirmed one way or the other.
It's Ms. Bailey, it's fine. The adjournment, the previous adjournment doesn't list a reason. It just says to adjourn the PCC. So I just wanted to make a note in the file that we're waiting for the prosecution to confirm the death of the complainant. We'll adjourn the PCC. How long do you need to verify that information, or do you want to project the time?
Your Honor, I think 1 more week should be sufficient.
I mean, the other option, Judge, is to schedule the exam, and when they failed to appear, we move to dismiss. My only thinking is it really doesn't matter to me if it's noli prost or dismissed, because you're never going to have her unless St. Peter sends her back. So whatever the court would prefer.
The court has no preference.
Prosecution?
Your Honor, I think I can figure this out within 1 week. If
It'll
Your
go
Honor
over-
wishes to.
It'll go, no, Ms. Bailey, you don't have to explain any further. It'll go over a week, October 12th. At what time, Marianne?
9:45.
At 9:45, back here in courtroom number 1. Anything else on behalf of the people?
No, Your Honor.
Anything else on behalf of the defendant?
No, Your Honor.
Mr. Hughart, thank you for being timely and appropriate this morning, sir. Your case is adjourned 1 week. Come back to the same Zoom at 9:45 next Wednesday, okay?
Yes, ma'am.
Thank you so much.
Have a good day. You too.
A
Ms.
lovely day
Michon,
to
have
you
a
and
good
your
day.
staff. Always lovely,
Thank you.
Judge.
And Marianne, this is how we start dragging this docket. Start at 8:30. We're ready. We need one visit too long in the breakout room and we just become something else.
Excuse me, Judge, did Mr. Childs log on?
I think we're still showing Mr. Childs in custody, aren't we?
Mr. Childs, he was out of custody to my knowledge. Oh, he's in custody. I didn't know that.
No, 8:30, being scheduled at 8:30 suggests to the court that he's in custody. Maybe he's not. Oh, no, it was a personal bond.
Right.
Your Honor, give me 1 second. He's either on tether or Division 2. Stand by.
Wait, what happened to Mr. Middleton?
Oh, Mr. Frierson, I talked to him last. Maybe that's why he's still seated there.
No worries. Are we ready on Mr. Frierson?
Yes, Judge.
This is 220630 FY. This is State of Michigan versus Brandon Charles Frierson. Have your appearances, please.
Good morning, Your Honor. Bryn Bailey on behalf of the people.
Good morning.
P84309.
Good morning. May it please this honorable court, Neighborhood Defenders by Rowea Epps Ward, P number 84898, on behalf of Mr. Frierson, who's present in the Wayne County Jail. Mr. Frierson, can you please state your full name for the record, sir?
Brandon Charles Frierson.
Thank you, Mr. Frierson. Today is the day and time set for the PCC in this matter. Ms. Epps Ward, how are we proceeding?
Judge, I do have discovery. That's why we had to come back today. So I have the digital, I have the paper discovery. So at this point, we would just need this matter scheduled for exam. And if the court, with the court's permission, if I could address bond also.
That live exam date will be
November 16th at 1 o'clock.
Thank you. That works. Thank you.
And bond is currently set at 20,000, 10%. Your argument, ma'am?
Your Honor, Mr. Frierson, he lives in Columbus, Ohio. He was here visiting his uncle in Sumter Township when this incident took place. Mr. Frierson has a bachelor's degree from Purdue in aeronautical engineering. He has a FAA power plant license. He works in Columbus, Ohio. While he's here, he's not able to work or get any money. Financially, he doesn't have the money for bond. So I would ask that the court please consider that. In addition to that, he has 3 children, Judge, and as long as he's here in custody, he's not able to pay child support or assist them, and school has started back. So I would ask that the court please consider those factors and a personal bond.
Ms. Bailey?
Your Honor, the defendant does live out of state, which does give the people some sort of concern. I believe Indianapolis is 4 to 6 hours away.
He lives in Columbus, Ohio.
Oh, Columbus, Ohio. I'm sorry,
That's not the address we have on record, Ms. Epps Ward, which causes the court some concern. If we have an Indianapolis address, then we would send notice to the incorrect address for Mr. Frierson. Sorry to interrupt you, Ms. Bailey.
No, Your Honor. Thank you, Your Honor. That highlights even greater concern is we have several different addresses, all of which are out of state. And I think that poses a concern as to whether Mr. Frierson will actually return. I'm reviewing his criminal history, and well, it appears he doesn't have anything aside from this case here. He does have a history out of Ohio. But I'm not at this point seeing any fail to appears. But I would make the argument that, Your Honor, that since we have 2 different addresses for him, both of which are out of state, I believe that the bond is appropriate as is. And if Your Honor tends to disagree, I think we should refer to DSU.
Judge, if I may address that.
Absolutely, ma'am.
Just briefly, Mr. Frierson, he did not. There's a lot of background noise. I don't know where it's coming from. Can you hear me, Judge?
I can hear you, ma'am. It's coming from the jail.
Oh, okay,
You're
I'm sorry.
fine.
So Mr. Frierson, he didn't have a chance to change that address to Columbus, Ohio. I'm not saying that that's an excuse, but he has been working there, Judge. He has a FAA license. I think that's remarkable in itself to be able to obtain that. So I understand the court's concern. I understand the prosecutor's concern. But the bigger issue is, how can he afford a bond if he's not able to work? Since COVID, these jobs are paid contractually. So if he's not there, he can't physically make any money.
Ms.
And then-
Epps Ward,
And then
I'm sorry.
I'm sorry, Judge. My last thing is, as Bryn mentioned, if she's mentioning the information that's in the police report and the discovery packet, he doesn't have any history of failing to appear. And since he's been in the Wayne County Jail, he's participated in group counseling sessions. He's trying to make the best out of the situation to show that he's responsible.
Okay, Ms. Epps Ward, these are the court's concerns. Mr. Frierson submitted a petition for a court-appointed attorney that lists his address in Indianapolis, and under employer's name and address lists not available, which makes the court concerned that he is not employed. The court does not want to be the reason why somebody is not able to work and provide for their children, but reviewing what he supplied to the court makes the court reluctant to change the bond. The court doesn't have any criminal history in the file, but will take you at your word that he does not have a failure to appear. Would ask that at the conclusion of your docket with the court this morning, you provide what you have confirmed with Mr. Frierson as his correct and accurate address.
Okay. I do have an address, Judge, from him. I'm not, this other information I wasn't aware of.
If you could provide that accurate information to the staff again, because when the new notice goes out, it will go to the address that you provide on the record. Mr. Frierson, raise your right hand for me, please, sir. Do you swear a firm testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you, sir. You may put your hand down. Prior to engaging Van Buren Township Police on September 5th, 2022, when's the last time you had contact with law enforcement?
The last time I'm not sure, it'd have been in 2017 or 18, maybe 19, I'm
Thank
not
you.
sure.
Sir, have you ever failed to appear for a court proceeding?
I have never failed.
Where do you currently live, sir?
I currently reside at 217 Grant Street, North Grant Street, Columbus, Ohio, 46215.
Good morning, Your Honor.
The court will grant the defense request and amend the bond to 20,000 personal.
Your Honor,
Ma'am,
if I may, the defendant just lied to you. He has
Lied to
criminal
me, sir.
contacts from 2020.
I said 2017, 18, or 19. I'm not sure which exact time that I've been in contact with a police officer. I didn't just lie to anybody. And the address on the license that the officers took from me, or that was on my phone, was the address from my house that was in Indianapolis, Indiana, 300 South Biltmore Avenue, Indianapolis, Indiana, 46213.
Your Honor,
I've been living in Columbus, Ohio since 2000.
Mr. Frierson,
Yeah, Mr. Frierson, just hold on a second.
Your Honor, I have
Ms. Bailey.
2 felony criminal contacts in 2020 and 2021. As well as 2 additional misdemeanor contacts in 2020.
Bryn, just for clarity, are you looking at the police report that's on page?
No, I'm
Right.
looking at his criminal history, his lien.
Okay, all right.
Ms. Bailey, what is it that you want? You want it to stay at 20,000, 10%, or are you looking for something else?
Your Honor, I think that I think that there's a lot of inconsistencies with what he's indicated and what the file indicates and what we all have. Whether it's Ohio or Indiana, I'm still concerned about returning.
So what are you proposing is the question. Are you proposing to
I'm-
leave the bond as is?
Yes.
Ms. Bailey, over your objection, the court is going to amend the bond as previously indicated. Mr. Fryer saying we'll do one of two things. He will either be a man of his word and show up to court, or he won't. It's that simple. And the court is under guidance to not be the reason why someone suffers financially. They shouldn't sit in jail because they can't work, because they're in jail because they can't post bond, and this court's next exam date is a month away. Over your objection, the bond's amended. Mr. Frierson, please, your exam is November 16th at 1 p.m. live here in courtroom number 1, 34th District Court. Anything else in this matter on behalf of the people?
No, Your Honor.
Anything else, Ms. Epps Ward?
No, thank you, Judge.
Mr. Frierson, we'll get the paperwork done November 16th here with me in courtroom number 1. Have a good day.
Thank you, you too.
We'll get Mr. Middleton back up. Good morning, Mr. Sullivan.
Good morning, Your Honor. I got Zachary Middleton, camera 1.
Thank you. This is 220-636-FY. This is State of Michigan versus Zachary Lynn Middleton. Ms. Bailey and Ms. Epps Ward, the court notes your appearances for the record. Mr. Middleton, state your name for me, please, sir.
Zachary Lynn Middleton.
Thank you. Today is the day and time set for the adjourned PCC in this matter. Ms. Epps Ward, how are we proceeding?
Judge, we do have full discovery now, digital and paper. So I would need this matter set for an exam.
Before we do, Ms. Epps Ward, in this case and in the previous case, I don't recall having seen you on this courtroom number 1's docket before. I want to disclose to you that I am married to an elected official in Van Buren Township. He does not have involvement in the day-to-day operations of the police department. I make this disclosure as Van Buren Township is the issuing agency for both Mr. Frierson and Mr. Middleton. My husband would have no idea that either of these cases are scheduled, the details of the case, or anything about how this court rules in these matters. Knowing that, ma'am, do you still wish to proceed with the exam with Mr. Frierson in this courtroom?
Yes, I have no concerns, Judge. Thank you.
And the same with Mr. Middleton?
That's correct, Judge. We have no concerns. Thank you.
Thank you. That live exam date for Mr. Middleton will be Mary Ann?
11/16 at 1:30.
11/16 at 1:30 p.m. Mr. Middleton here in courtroom number 1, live exam.
Your Honor, if I may address bond with Mr. Middleton as well.
Absolutely, ma'am.
Mr. Middleton was working at Sealright. Sealright, they seal asphalt, they pave driveways. Again, this is a situation where, Judge, he has to be out working. He does have 2 small children that he's active and involved with. He's required to pay support. They're 3 years old, 5 years old, even for daycare expenses. He hasn't been making any money since he's been locked up. He's very candid. He does have issues with alcohol. He'll even do an alcohol tether monitoring, whatever the court needs him to do to comply. He doesn't have any history of failing to appear. So I would ask that the court take that in consideration and grant and bond for Mr. Middleton.
Ms. Bailey, your response.
What is his current bond?
5,000, 10%.
Your Honor, we have an aggravated indecent exposure. I think that that is a completely appropriate bond. I have 3 prior cases listed for the defendant. Drinking issue, 2 drinking issues, Your Honor, and now we have an indecent exposure aggravated. I think 5,000, 10% is completely appropriate as is.
Your Honor, if I may address,
Yes, ma'am.
the previous cases that Sister Counsel is referring to have nothing to do with indecent exposure. I was very candid in being forthcoming that my client admits to having drinking issues. These allegations are just that, allegations. We haven't even met a probable cause standard yet. I'm still doing a lot of legal research, so I appreciate the November date because I'm trying to see if there's a more fitting crime, because we may even waive exam, but this based on my limited research, I don't think it even meets this criteria. I think that it's too quick to make a knee-jerk slap reaction about what the charges are when we haven't reached the probable cause standard yet. And I understand, you know, the amount of bond, but if he's not working, it's not uncommon that most people are only paid per job during COVID. It's a different time and era now. He can't be expected to pay for something if he's not able to get the money to earn it. So I would ask that the court please consider a personal bond. As I mentioned too, he even admits I'll do an alcohol tether problem because he has a lot of insight. I've already arranged for a social work advocate to help him with outpatient treatment. So we're trying to be proactive here, Judge. And again, he has a 3-year-old and a 5-year-old. I don't want this child support to rack up and become more overbearing for him.
Ms. Epps Ward, respectfully, the court will deny your request to amend the bond in this case. I understand that you are indicating that the allegation is that just an allegation that you're doing research, but the court has concern that Mr. Middleton has 2 convictions from 2020, not terribly long ago. So the court has some concerns about him remaining having a deleterious effect in the community. We'll leave the bond as it is. We will see him here on November 16, 2020 at 1:30 p.m. live in courtroom number 1. Anything else on behalf of the people in this matter?
No, Your Honor.
Anything else, Ms. Epps Ward?
No, thank you, Judge.
Thank you. Mr. Middleton, I will see you here on November 16th at 1:30.
Okay, thank you, Your Honor.
Thank you.
I'll see
Good
you later,
morning, Ms.
Mr. Middleton.
Hamilton.
Thank you.
Good morning, Your Honor.
How are you today?
I'm pretty good so far.
It feels like I haven't seen you in a long time, and I don't think that that's true. You're
Yeah,
here
it has
for
been-
Sutton?
I'm here for Sutton, and then I think they might be scheduled for a little bit later, Bryant Brown and Scott Moore.
We're showing Sutton in custody.
Yes.
Okay. Wayne County's already on. I don't know who they're, well, they were on. I don't know who they're putting up next. Are there any matched sets? Oh,
Judge Sutton is from Division 2. And the jail signed off because they have to go in to a different area for Mr. Brown.
understood. Thank you, ma'am.
You're welcome.
So we'll hold on, wait for Sutton's connection. I'll pull the Brown file. I see Mr. Robinette here. We haven't seen Mr. Hatchett yet, but we're still a little early. Ms. Bailey, did somebody reach out to you regarding Douglas Adams? That's 220652 at 9 a.m.?
Yes, ma'am.
Okay. And also at 9 a.m., Adam Gandor, Ghandour.
That one I haven't heard anything.
He retained counsel
Oh, okay.
recently, and they adjourned it. The clerk's office adjourned it.
No, but I did, I believe Mary Ann reached out to me about Mr. Adams.
Okay. Mason Gaith, Ghaith, is the attorney for Adam Gandor, and the new date is arraignment pretrial on November 2nd with Judge Green.
Thank you, Your Honor.
You're welcome. Mr. Childs, remove your cap. Ms. Epps Ward, do you need to speak to him?
Yes, please. That's for Mr. Childs, Judge.
Yes.
Yes, please. Thank you.
Mr. Childs, you'll see an invitation, go into a breakout room to talk to your attorney. Please join her there.
Will do.
Thank you. Good morning, Ms. Dennis.
Good morning. How are you doing today, Your Honor?
I'm wonderful. How are you, ma'am?
Wonderful. We're going to get 77 degrees today in the middle of October. What more can I ask for? I should
tried
be
to
putting
convince
on
my
my
husband it
Christmas
was too.
lights.
I told him it was too early to bring in the deck furniture and take down the hammock. I told him it was going to be warm again.
I know. I didn't either. I think I'm aiming at Halloween. I mean, I don't even want to cut my flowers down. They still look like summer.
I know.
But it's going to drop
I
this
will take
weekend.
Michigan with all of its seasons.
I know, but I wouldn't have it no other way.
Mm-mm.
I haven't found a town I'd rather have rather than Four Seasons.
Oh.
Righty. We
Too
haven't
many
done any
attorneys and
yet,
not
have
enough
we?
defendants.
We
I'm
haven't
sorry?
done any cases yet, have we?
Of course we have, ma'am. It's 9:08. We've done 3 cases.
Oh, okay. Do we do Childs,
No, that's up next.
Middleton?
We set the Middleton exam for November 16th at 1:30.
With you
Yes, ma'am.
and Hogarth?
That's been adjourned over to next Wednesday at 9:45 a.m. Back with me. To the gentleman that
Alrighty.
just joined me with the button-up shirt on, with the beard. Yes, sir. Your name, please.
Scott Poor.
I'm sorry.
Scott Poor.
Mr. Port, your attorney is here. Ms. Hamilton, you need to speak to him. Attorney Hamilton?
This is Hatchet. Good morning, Your Honor.
Mr. Hatchett, I see you. Give me one moment, please, and stop
Thank
chewing
you.
gum.
Okay.
Attorney Hamilton,
Oh, I'm sorry, Judge.
you're okay. I'm just trying to get the earlier case connected with. She's here, sir. If you sit tight, we'll see if she needs to speak to you. Mr. Hatchett, did you need to speak to Mr. Robinette?
I've talked to him, but I would like to speak with the prosecutor before we start.
Absolutely. She is here. We'll get you into a breakout room with Miss Bailey.
Okay. Okay, thank you.
Miss Bailey? Officer Horizonte?
Hey, good morning, Judge.
Good morning. Who is that with you, sir?
This is Mr. Devon Sutton.
Mr. Sutton's attorney is here. Ms. Hamilton,
Yes.
I'm gonna have you talk to Mr. Sutton first. Mr. Poor is here, but we want to get Mr. Sutton seen.
Sure, yeah.
Mr. Poor, can you join the breakout room, please?
Are you trying to get Mr. Robinette to move?
No.
Okay. Oh, no. Good morning, Mr. Seal.
Good morning.
How are you, sir?
Good.
I have not seen your attorney as of yet, sir, but if you sit tight, as soon as Ms. Nelson appears, we'll get your case called and get you on your way, sir.
She says, wait for your attorney, sir. And
Oh,
and as
okay.
soon as the attorney gets in, she'll take care of you, okay?
Oh, okay.
If you have any more questions, you just come out and if you need help, come get us, okay?
Okay.
All right, thank you.
Attorney Hamilton, did you need to speak to the prosecutor about Mr. Sutton?
No.
Okay, that's the. Ms. Epps, for Mr. Childs has a misdemeanor warrant out of Sumter. When we call the felony matter, I'll get that warrant recalled and get him rescheduled. Mary Ann, we'll need a date for Sumter for Mr. Childs, please.
Okay, Judge.
Thank you.
That's going to be November 16th at 9:20 with Judge Green.
For Mr. Childs?
For his misdemeanor matter, yes.
Okay. He's still in the
When Ms.
breakout.
Bailey I know, I'm not calling his cases yet. I just wanted you to
Oh.
know, so when I say it on the record, you're not surprised. We'll call
Okay.
Mr. Sutton's case first. He's in custody. This is 220642 FT. This is State of Michigan versus Devon Sutton. May I have your appearances, please?
Good morning, Your Honor. Bryn Bailey on behalf of the people, P84009.
And good morning, Your Honor. Vanessa Hamilton, P82107, on behalf of Mr. Sutton. Mr. Sutton's joining us from Wayne County Jail via Zoom.
Mr. Sutton, state your name for the record, please, sir.
Devon Leonte Sutton.
Thank you. Today is the day and time set for the adjourned pretrial. Attorney Hamilton, how are we proceeding this morning?
Your Honor, we've got discovery, and so we'd be looking to set a preliminary exam date. We'd also like to make a bond argument.
That live exam date will be
November 16th at 2 o'clock.
November 16th at 2 p.m. live here in courtroom number 1 with me. Your bond argument bond is currently 100,000, 10%.
Mr. Honor, that's been something that my client and his family have been unable to post, and he was hoping to be released possibly on personal with a tether or something along those lines. From what I can see, based off the case, there's not significant and any sort of significant failure to appear history. Let's see. And I mean, I do recognize that the charges are clean and eluding. But looking at least looking at the situation, looking at the specifics of the case, I can tell you that it's not. It's not all. There's not at least I'm not sure where some of these additional assaulting charges come in terms of interaction with the police officers. He is being alleged to have driven away during a traffic stop, but there's not anything in terms of danger to the public or otherwise that I'm seeing from the specifics in this case.
Ms. Bailey.
Well, Your Honor, I see a full extradition warrant from, it looks like 2017, from the US Marshals. I'm trying to find out where that's from, like
Yeah.
what state. But I see that another warrant for failure to comply with terms of probation.
It is, yeah, those two, I
Hold
think,
on, hold on.
Yeah,
I'm
Your
sorry,
Honor,
Ms.
I
Bailey,
think
were
he's
you
on-
finished?
No, I'm looking at his record. It's a little rough because it's an out-of-state one. But I see 2, possibly 3 warrants from federal probationary officers, Your Honor, for failure to comply. It looks like one of them is from the Southern District of California. So, Your Honor, I think that the defendant does have an issue with appearing and returning to court, and has failed to comply with terms and conditions of probation, and in another state, in another court at I believe a federal level. So, you know, Your Honor, while I do respect that is a high bond and we are not necessarily looking at something immensely assaultive, I think the fleeing and eluding and the reckless driving does show a disregard for the law and for people's safety. And additionally, Your Honor, fleeing and eluding is in and of itself an indication that the defendant is not going to comply, or could possibly not comply, and could possibly flee. So if Your Honor is inclined to reduce it, I think that there might possibly be an extradition hold on him anyway.
Anything else, Ms. Bailey?
No.
Anything else from the defense?
no, simply that, yeah, initially that is why we did not make a bond argument. But my client has told me that there's been absolutely no movement or suggestion that he's going to be extradited anywhere. We've received no contact. He's received no contact of that nature. And while he is prepared to deal with those additional issues, you know, in the meantime, if he's able to function outside of Wayne County Jail, he'd have a lot better of a go at it.
Thank you. Respectfully, Attorney Hamilton, for the reasons articulated by Ms. Bailey, the court will deny the request to modify bond at this time. Mr. Sutton submitted a petition to the court that shows him as being an out-of-state, coming from Nevada, being homeless and being unemployed. The nature of the allegations against him raised some concern about his threat to public safety. Leaving the bond as is. We will see Mr. Sutton here in person on November 16th at 2 p.m. Anything else, Ms. Bailey?
No, Your Honor.
Anything else, Attorney Hamilton?
No, thank you.
Thank you. Mr. Sutton, I'll see you on November 16th, sir.
Okay, all right, thank you.
Thank you. This is 220655 FY. This is State of Michigan versus David Lewis Childs II.
Good morning, Your Honor. Sonam Movsisian on behalf of the people, PH 122.
And good morning again. May it please this honorable court, Neighborhood Defenders by Roia Epps Ward. My P number is 84898 on behalf of Mr. Childs, who I believe is in the gallery. I think he got stuck in the waiting room.
He was, hold on one moment. No, you left him in the breakout room.
I don't know if he can get out, if he knows how to get out for me.
Well, I sent him a request to return here. While we're waiting for him to return, Mr. Hatchett, are you ready with your client?
We are ready, Your Honor.
This is 220446 FY. This is State of Michigan versus Ryan Hunter Robinette. May I have your appearances, please?
Good morning, Your Honor. Bryn Bailey on behalf of the people, P84009.
William Hatchett, John, I appear on behalf of Ms. Robinette, P23350, and we do consent to proceed by way of Zoom.
Thank you. Mr. Robinette, unmute yourself and state your name for the record, please.
Ryan Hunter Robinette.
Thank you. Today is the day and time set for the appears to be 5th or 6th PCC in this matter. Mr. Hatchett, how are we proceeding?
Your Honor, the record should reflect, I've had an opportunity now to speak with the prosecutor on a number of occasions regarding this case, and we are prepared at this time to tender a plea to the reduced or added counts. I'll let the prosecutor put on the record exactly what the agreement is.
Yes, Your Honor. At this time, the people have offered attempt, resisting, and obstructing a police officer with a plea to count 2 under 771 if eligible, with terms and conditions set by the court, 1-year probation, mental health assessment and treatment as recommended, fines, costs, and any other terms and conditions set by the court.
And Your Honor, we'd like the record to reflect that we want to proceed by way of no contest to the plea. The defendant does not have an accurate recall of the events of that day. He does suffer.
Mr. Hatchett, I'm sorry, sir. I couldn't hear you.
I apologize, Your Honor. The defendant is prepared to plead no contest to the charges as stated by the prosecutor.
Ms. Bailey, you said 771 if eligible.
Yes.
Correct, Your Honor. I think that's a determination made by probation. I don't see anything on his criminal history which would prevent him from being eligible.
Yes, we believe he has no prior criminal history, Your Honor.
Okay. Mr. Robinette, raise your right hand for me. I'm sorry, what's happened to count number 2, Ms. Bailey?
Plead guilty to that as well, or no contest. I apologize, Your Honor.
No contest. Mr. Robinette, do you swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you, sir. You may put your hand down. You understand that the court accepts your plea this morning to the added count of attempting, assaulting, resisting, obstructing police officer and reckless driving. You will not have a trial of any kind in this matter?
I do.
You
Understand,
will
yeah.
not have the opportunity to present witnesses on your own behalf or see and cross-examine witnesses put forth by the prosecutor.
I agree.
And sir, you're entering this plea freely and voluntarily?
I am.
You haven't been threatened in any way, promised anything to get you to plead no contest in these matters?
I have not.
Mr. Hatchett, inasmuch as your client's pleading no contest, would you like to establish the factual basis for the plea?
Yes, Your Honor. On the date in question, the defendant was attempted to be stopped by the police department, and he refused to pull over initially. He did run a stop sign, and at that time, the officer did make contact with him. Mr. Robinette panicked and refused to leave his vehicle, and he had to be extricated from his vehicle by the police department, leading to the charges against him. And that is the basis. And he does not have accurate recall of everything that occurred that day because he suffered from PTSD. And as a result, we ask that the court allow this plea to be taken no contest.
Satisfied, Ms. Bailey?
Yes, Your Honor.
Sir, Mr. Robinette, the court will accept your plea of no contest to the added count of attempting, resisting, obstructing, and no contest to the reckless driving. The matter will be referred to the probation department to confirm your eligibility for such a plea. Ms. Bailey placed on the record that there will be 1-year probation mental health assessment. The probation department, after the screening with you, will schedule the matter for actual sentencing. We'll have you come back by Zoom. The probation department will reach out to you at the phone number and the email address that you confirmed this morning. So please be responsive to their efforts to communicate with you, okay?
Yes, miss.
Anything else, Ms. Bailey, in this matter?
No, Your Honor, nothing from the people.
Nothing,
Anything else, Mr. Hatchett?
nothing further, Your Honor.
Beginning of a 10:15.
Thank you.
Thank you.
Mr. Childs,
Right.
I'm sorry, Mr. Robinette, you have a good day, sir. I'll see you for sentencing.
Thank you, Judge and members. Thank you.
Thank you.
Thank you.
Call me
This is a
Rob.
recall of 220655FY. The court has already taken the appearances of the attorney. Mr. Childs, please state your name for the record, sir.
David Childs.
Thank you. Today is the date and time set for the PCC in this matter. Ms. Epps Ward, how are we proceeding?
Your Honor, we do have discovery. We just need to set this matter for an exam.
That live exam date will be, Mary Ann, November 16th at 2:30.
Got it.
November 16th, 2022 at 2:30 PM here in courtroom number 1. Is there anything else in the felony matter, Ms. Moisezian?
Judge, just for clarification purposes, the discovery was sent yesterday. The only outstanding part of that discovery is the 911 calls, which the detective is aware of and plans on getting it and uploading it for me. I just wanted to let defense counsel know that that's the only thing that we are waiting on. Everything else was shared.
Thank you.
Thank you. And then, Mr. Childs, you have 22SU00749A OT. This is Sumter Township versus David Childs. Mr. Childs, the Neighborhood Defender Services does not represent in misdemeanor matters. There's a warrant outstanding for your failure to appear previously. This is a driving while license suspended from July 11, 2022. It has your address in Wayne, sir. Is your proper address on Utah Street?
My house was on Utah. It wasn't 340, it was 353. It burned down 3 months ago.
So 353 is a good address?
No, the good address is actually in Hennepin for Garden City.
Did you provide that information to the clerk this morning?
Yes, I did.
Okay. There is not a prosecutor here from Sumter this morning, Mr. Childs. So what the court will do is recall the warrant
I
on the
appreciate that.
misdemeanor driving while license suspended and schedule the matter for arraignment pretrial on November the 16th at 9:20 a.m. That will be by Zoom with Judge Green. Notice will be mailed to the address that you provided this morning.
Okay.
Okay? Anything else, Mr. Childs?
No, Your Honor.
We're all set, sir. You have a wonderful day.
Thank you. You as well.
Thank you.
Judge, the time was 2:30, right? Just to confirm.
Yes, ma'am. For the exam?
Yes, thank you.
Yes, ma'am. Is Attorney Hamilton ready with Mr. Poor?
Your Honor, I would need a breakout room with Miss Bailey when appropriate.
I'm with you, Mr. Bowditch. Give me 1 second. I can see Attorney Hamilton. I'm not sure why she's not responding. We want to get Mr. Poor's case called. Ms. Bailey, if you want to go ahead with Mr. Bowditch. Thank you. I'm sorry, Mr. Sullivan, were you ready with Mr. Jones?
Morning, Judge. I think we're still, Mr. Jones is here. Yeah, I'd request a breakout room with him before the case is called.
Okay, we'll get you moved in with Mr. Jones and Miss Bailey's gonna go in with Mr. Bowditch quickly.
Thank you, Judge.
Mayor, can you make me co-host, please?
There, yes.
No.
Yes,
Heather,
please. I need to help
inserting
clerk
yourself.
things.
You gotta do clerky type things. Ms.
I
Hamilton, are
do.
you ready with Mr. Poor?
Yes, I am ready.
Oh, I was
with
trying to
this.
call your, okay.
Sorry, I'm in like
And Miss-
3 different courtrooms at once.
I understand that. When Ms. Bailey returns, we'll call Mr. Poor first, and then we'll get Mr. Jones and Mr. Sullivan. If anyone's able to get in touch with Sophia Nelson, would you let her know that Mr. Edsel still is here? Oh,
I'm here, and I know he's in person.
I didn't see you. Oh my goodness. Did you need to speak to him?
Yeah, breakout room would be great.
Oh, that's why I wasn't looking for you. Scheduled at 9:30. We'll get you into a breakout room with Mr. Steele. Mr. Steele, you'll see an invitation to go into the breakout room. If you need some assistance, just open the door and let the officers know.
Okay.
Thank you, sir.
The court officer's on his way to help Mr. Steele.
I said it last week, Marianne, and I'm gonna stand by it. That room is screaming for a horizontal band of color or a picture or something. That has got to be the most dry and boring room in this building.
Agree more.
Thank you, sir.
You're welcome.
So Marianne, here's the question of the hour. Do we double up on the 16th?
Oh.
I can't go to the 23rd.
It's just right around the corner.
That is not around the corner. You and I don't have the same concept of time.
Oh, I don't know.
Well,
I guess it depends on the chart.
can we set an exam at 11:30?
On the 16th? No, you're already, you start, oh wait, you know what, our 11:30, let me double check, hold on.
We don't have anything at 11:30. I can't go to November 23rd. I can't say November 23rd on October 5th. That sounds.
Okay, yeah, 11:30, I had it white, yes, 11:30 is open.
We'll schedule so many exams in the morning that we can't do any PCCs.
I bet we could probably even squeeze an 11 o'clock in there, you know? I mean, if there's a formal, they're so quick.
I'm okay with doing that, because I accept that every 5th and 6th Wednesday will be no lunch and we'll be busy, which is perfectly fine. Or we'll just schedule a dozen exams at noon and whoever shows up first is who we call.
A free
Nobody shows up on time anyway. That is tongue firmly in cheek. We will schedule, as we always have, a half hour for each exam. I don't double up unless they tell me to. They, the attorneys. Good morning, Ms. Jones.
Good morning. I'm here on
Ma'am, do you
Stephanie's.
expect your, yes, do you expect your client, is she with you or do you expect her to appear separately?
I thought she was going to appear separately.
Okay. It's not scheduled till 9:45. We have a couple of earlier things still kind of popping around. When she appears, do you need to speak with her?
I'm going to give her a call right now to see if she's on her way.
Thank you. I said go briefly into the breakout room so that we can get these other things done. Oh, there's somebody in my DC waiting room. Yeah. Uh-oh. Thank you, Joe.
You're welcome.
Uh,
Do you want me to get Bryn back out here?
I just sent her a message to come so we can get Mr. Hamilton, Mr. Steele, and Mr. Jones on their way. Oh, you know what? Mr. Sullivan's still in with Mr. Jones, but I'm ready to get Mr. at least Poor and Steele on their way. Mary, can you force her out? Or I thought that
I tried that.
I tried to.
Yes, ma'am.
Ms. Bailey, sorry to interrupt your breakout room, but I have Mr. Poor, who's been here since well before his 9:15. This is 220-643-FY, State of Michigan versus Scott Allen Poor. May I have your appearances, please?
Good morning, Your Honor. Bryn Bailey on behalf of the people, P84009.
Hey, good morning, Your Honor. Vanessa Hamilton, P82107, on behalf of Mr. Poor. He joins us via Zoom.
Mr. Poor, state your name for me, please, sir.
Scott Allen Poor.
Thank you. Today is the day and time set for the PCC. Attorney Hamilton, how are we proceeding?
Your Honor, we'd like to set a date for preliminary examination.
November 16th at 11:30 a.m.
Works for me, Your Honor.
You said 11:30, Judge?
I did.
Okay, thank you.
Thank you. That'll be a number one. Discovery complete in this matter?
Yes.
Mr. Poor, I will see you in person in courtroom number one on November 16th at 11:30 a.m., sir.
The 16th, you said?
Yes, sir.
Thank you.
Anything else on behalf of the people?
No, Your Honor.
Anything else on behalf of Mr. Poor?
No, Your Honor.
Mr. Poor, were you asking a question? Did I cut you off, sir?
No, I'm all set.
Thank you. You have a wonderful day. I'll see you on the 16th.
You too.
Thank you. This is 220-668-FY, State of Michigan versus Derek William Ryan Jones. May I have your appearances, please?
Good morning, Your Honor. Sona Movsisian on behalf of the people, P 83923.
Mr. Sullivan?
Oh, sorry. Neighborhood Defender Service by Andrew Sullivan, P84261, here on behalf of Derek Jones, who is present here by Zoom. We have no objection to his appearing by Zoom. Mr. Jones, can you state your name for the record?
Derek Ryan Jones.
Thank you. Today is the day and time set for the PCC in this matter. Mr. Sullivan, how are we proceeding?
Yes, Judge, requesting all paper and digital discovery on the case. Additionally, requesting to be heard on bond conditions. Mr. Jones has a contract. He works in like a tree removal. He has his own tree removal company. He has a contract with the Town and Country Mobile Home Park, where the complaining witness currently resides. His contract sort of requires that he do tree removal, and right now there is a tree that's fallen onto a house in that park, and so the park is calling him, asking him to sort of do his job, but he's concerned because he has a tether and has been told to, have no contact with the complaining witness. So I just wanted to address Your Honor on this issue. Obviously, he's not going to be on the complaining witness's property. He's not having any contact with her. But if he may have permission to just enter the park for this limited purpose of doing his job, this is his livelihood.
Madam Prosecutor?
Judge, the people have no objection to that.
Mr. Hamilton, Mr. Sullivan, the way that the restriction is a specific address, is that 6603 Outer Drive the Town and Country address or the specific unit address?
Mr. Jones, can you clarify that? Does the park have a single address?
The 6603 is the victim's address.
Is the what, sir?
The victim's address.
The bakery address?
The victim's
complaining
The
witness
victim's address. So it's not the park. So the defense motion to amend the bond restriction to allow Mr. Jones to return to Town and Country for purposes of fulfilling his contract is granted.
Judge, if I may address the discovery, I guess, request of Mr. Sullivan's.
Yes, ma'am.
So I did submit all of the discovery yesterday. I sent it to the general discovery at NDS, I guess, email address. I don't know if Mr. Sullivan has that. Otherwise, I can also send it directly to him, but everything has been uploaded and shared.
Very good. Sometimes it just takes a day for our paralegals to enter that into sort of my file where I can see it. So no issue there.
That being the case, we're looking at presuming at an adjourned PCC date. How far out, Mr. Sullivan?
I would be available. Could we do November 2nd? Or next week?
November 2nd is fine. I just don't have the time. Marianne will give us the time on November 2nd.
I'm sorry, is that for an exam or an adjourned PCC? I don't think
Adjourned PCC.
I don't know if we'll need 4 weeks for an adjourned PCC on this.
Yeah, and Judge, I'm comfortable with Ms. Movsisian's representation that discovery has been sent. If we want to schedule it for a preliminary exam today, I think that would be fine.
Mr. Sullivan, it's your case. First you said a week, and then you said November 2nd, and now you're saying exam. The court will schedule whatever you want to schedule. So do you want the brief PCC adjournment, or do you want an exam date this morning?
Let's schedule it for an exam, please.
Mary Ann, it dawned on me that we have scheduled Ms. Mosizian exam on our Wednesday, which is already a busy Wednesday. Should we try a different date, or are we gonna put her on Wednesday, November 23rd?
Whatever, whatever you want to do, Judge.
We'll put it on the 23rd. What's the first, do we have anything scheduled, or what's the first time on that date?
First time open is 12:30. Yes, we do have two
12.
for that.
12:30 on November 23rd, in person for Mr. Jones in courtroom number 1. Anything else on behalf of the people?
No, that is all. Thank you.
Anything else, Mr. Sullivan?
Nothing additional, Judge, just confirming November 23rd at 12:30.
Yes, sir.
Very good. Thank you very much.
We'll see you then, Mr. Jones. Have a good day.
Thank you, too.
Thank you. This is 192190 FD. This is State of Michigan versus Edsel Gilmore Steele. May I have your appearances, please?
Good morning, Your Honor. Bryn Bailey on behalf of the people, P84009.
Good morning, Your Honor. Sophia Nelson of Neighborhood Defender Service on behalf of Mr. Steele, P77960. Mr. Steele, could you please state your name for the record?
Edsel Gilmore Steele.
Thank you, Mr. Steele. Today is the day and time set for the PCC. Ms. Nelson, how are we proceeding?
Your Honor, the people and the defense have come to a plea and settlement agreement in this case for sobriety court. Mr. Steele needs to get evaluated, is my understanding, by probation before a plea can be entered. So I suppose we're asking for an adjourned PCC so Mr. Steele can call probation and be evaluated. The one issue I have is Mr. Steele is 90 years old, and we have agreed to 2 years probation, no jail up front. But I understand sobriety court is in front of Judge Green. And so if an adjourned PCC could be set in front of Judge Green so we can be ensured that she's comfortable with that agreement and that she understands and agrees that a 90-year-old with health conditions shouldn't be put in jail, that would be helpful.
So the notation in the file is that Mr. Steele's case is referred to probation for evaluation for sobriety court. We'll adjourn the PCC date to.
Well, we could do it next week, Judge, because she's going to be hearing.
But will that give probation enough time to talk to him and evaluate him for admission to sobriety court?
Probably not. Let me get a Judge Green PCC date. Hold on 1 second, please.
Thank you, ma'am. While we're waiting, are you ready on Davies when we conclude, Mr. Steele, or do you need to talk to Mr. Davies?
I know we're ready. Well, I guess I actually would like to talk to Brent on that case.
Then we'll wait. I thought Mr. Belders was ready on a couple of misdemeanor matters.
Your Honor.
Or nope, I see another one. Let me get this date from Mary Ann and we'll figure out what we're doing next.
9:30 on November 2nd.
November 2nd, 2022 at 9:30 a.m. That will be in number 3 with Judge Green. It'll be on Zoom with Judge Green on November 2nd, 2022, 9:30 a.m. In the meantime, Mr. Steele, the probation department will be in touch with you to evaluate you for sobriety court. Okay, sir?
Okay, I heard you. Thank you.
Thank you. Anything else on behalf of the people?
No, Your Honor.
Mr. Steele, you're free to go home, Mr. Steele.
All right. Thank you very much.
You're welcome.
Thank you. Have a good day.
Thank you.
Ms. Jones, were you ready with Ms. Sutton?
I did want to speak with the prosecutor before I'm sorry, Your Honor.
No, I'm sorry. It's just what I ask people, are they ready? And they It's fine. We'll get you in. We'll get Ms. Nelson in with Ms. Bailey, and then we'll get you in with her as well. It's fine. It's not a problem. Good morning,
Thank
Mr. Gazicki.
Good morning.
Is your client with you, or are you expecting him to join separately?
I'm expecting him to join in. In fact, I'm just putting a call into him now because I don't see him.
Thank you. Mr.
Okay.
Bowditch, were you ready on something?
I was ready, Your Honor, on Mr. Ellis Bookrum at 9:30. And then I'll need to talk to Miss Bailey for a second about a second matter.
Mr. Bookrum,
Yes.
could you turn your video on for me, please, sir? This is 22-RP-03559-ST, State of Michigan versus Ellis Bookrum Jr. May I have your appearances, please?
Your Honor, for the record, Jeffrey Bowditch, 45367, appearing on behalf of and with Mr. Bookrum.
State your name for me, sir.
Ellis Bookrum.
Your Honor,
Thank you.
today's
For
the
purposes
date.
of arraignment, Mr.
We would waive formal reading and stand mute in anticipation of the judge's request. Ask the court to enter a not guilty plea. And then, Your Honor, I've spoken with Miss Bailey about this at some length. Miss Bailey wishes to dismiss these charges. Mr. Bookrum and I have no objections.
That is correct, Your Honor.
Anything else, Miss Bailey?
No.
Mr. Bookrum, you're free to go, sir. Have a good day.
You too. I
Case
appreciate
is
it.
dismissed.
Thank you.
You're welcome.
Does Miss Bailey have the domestic matters today?
Does she have what?
I know there's more than one prosecutor. I didn't know if Miss Bailey had the domestic matters today.
I have Macris and Koza.
I have those.
I think I had a witness in my breakout room for that I haven't been able to get in touch with yet.
I think that'll have some bearing on our moving forward today.
Okay, I'll go talk to him.
All right, thank you, ma'am.
Or her.
I thought that we saw. Mr. Oh, no.
Can I get put in the breakout room with Brent?
She's in with a victim. If you sit tight, we'll get you queued up to go in with her.
Thank you.
You're welcome.
I need Bryant Brown and cell 1.
You just couldn't stay away, could you?
Morning, Your Honor.
Good morning again.
I got Mr. Brown. He's en route to me right now. I'll be just a couple seconds before I get him on camera.
Thank you. Ms. Hamilton's here for him. Did you need to speak with Mr. Brown?
No, Your Honor. We've already met.
That's the first case when Ms. Bailey comes back out.
Good morning.
Hello,
Good morning, Mr. Brown.
good morning. Your Honor.
Mr. Brown, we're just waiting for the prosecutor to return to the main session and we'll get your case called.
Okay then, good morning, Your Honor.
Thank you.
Yes,
Morning.
ma'am. Yes, ma'am.
Your Honor, on Attard, I left a voicemail message for him. I talked to him the other day. They're supposed to zoom in. We're going to request an exam. Is there any way of waiving his presence for today, or must he be here?
We could possibly do that when we get there at the 10 o'clock. When I have it in custody from 8:30, we'll do that first, and then we have a couple of 9:45s ready to go. But I have
Okay.
Mr. Attard's file queued up, sir. Thank you.
Thank you, Your Honor. Okay.
I sent a message that we're ready. This is 220633 FY, State of Michigan versus Bryant Brown. May I have your appearances, please?
Good morning, Your Honor. Bryn Bailey on behalf of the people, P84009.
And good morning, Vanessa Hamilton, P82107, on behalf of Mr. Bryant Brown, who joins us from Wayne County Jail via Zoom.
Brown, state your name for the record, sir.
Brian Brown.
Thank you. Today is the day and time set for the adjourned PCC. Attorney Hamilton, how are we proceeding?
Your Honor, we like to set a date for preliminary exam and also make a bond argument.
That live exam date will be November the 23rd, 2022. Are we at 1 p.m., Mary Ann?
Yes.
At 1 p.m. in courtroom number 1. Bond is currently set at 20,000, 10%. Your argument, please.
Your Honor, we'd ask that if possible, bond be lowered. It's an amount that my client and his family have been unable to meet. The circumstances in this particular crime are non-assaultive. He's alleged to have taken something out of a parked vehicle that with the windows open. And as far as I can see in terms of record, there's not anything that to me that would suggest a significant flight risk or a risk to the public.
Ms. Bailey?
Your Honor, I don't have a criminal history to show any fail to appears or lack thereof. I'll leave it in Your Honor's discretion. I would just ask if Your Honor is inclined to reduce the bond that you have a GPS tether.
Attorney Hamilton, when you say more reasonable, what's the dollar amount that you're referring to?
I guess I would say a more reasonable in the sense of a personal bond or something that wouldn't require them to put forth assets of that nature.
The response to the prosecutor's request for a tether?
That would be acceptable.
Defense motion is granted to amend the bond to 20,000 personal, defendant not to be released without GPS tether. Mr. Brown has some other unrelated matters with this court. He owes the court $900 upon his release. He needs to contact the court's collections department to make arrangements. Other than that, again, the exam is November 23rd at 1 p.m. Anything else on behalf of the people?
No, Your Honor.
Anything else on behalf of Mr. Brown?
No, Your Honor.
Mr. Brown, you have a good day. I'll see you on November 23rd, sir. Thank you. You too, sir. This is 220194 FY, the State of Michigan versus Anthony William Davies.
I'm here, Your Honor.
Good morning, Your Honor. Bryn Bailey on behalf of the people, P84009.
Good morning, Your Honor. Sophia Nelson of Neighborhood Defender Service on behalf of Mr. Davies, P77960. Mr. Davies is present via Zoom. Please state your name for the record, Mr. Davies.
Anthony Davies.
Thank you. Today's the day and time set for the PCC in this matter. Attorney Nelson, how are we proceeding?
We would like to set this matter for an exam.
Discovery complete, ma'am?
Yes.
That live exam date will be November the 23rd, 2022 at
1:30.
Mr. Davies, do you understand that date is for an in-person court hearing in Romulus?
I'll have it set up.
All right. Thank you so much.
Thank you.
You have a good day.
November 23rd, 1:30 p.m. live here in courtroom number 1. Mr. Davies, you have a wonderful afternoon. Anything else on behalf of the people?
No, thank you, Your Honor.
Anything else on behalf of Mr. Davies?
Sorry, thank you, Your Honor.
No, you're fine. Thank you, sir.
No, Your Honor.
Thank you. This is 220054 FY. This is State of Michigan versus Stephanie Renee Sutton.
Good morning, Your Honor. Bryn Bailey on behalf of the people, P84009.
Ms. Jones? Ms. Jones is still in your waiting room, Ms. Bailey, but we have 220607 FY. This is State of Michigan versus Michael Aaron Attard.
Good morning, Your Honor. Sonam Movsisian on behalf of the people, P83923.
Mr. Gazicki?
Sorry, Your Honor, I didn't know you called the case. James Gazicki on behalf of Mr. Attard. I don't think he appeared, Your Honor. I'm asking to waive his presence and request an exam.
Judge, I would object to that waiver. And I have my reasons for that, which I can put on the record.
Absolutely.
Yes, Judge. The people have serious concerns in regards to this case. I actually appeared at the AOI and requested a higher bond than was given for multiple reasons, including the defendant's flight risk, as well as the seriousness of this crime. He is on a GPS tether, and therefore the fact that he is not here today, and he was here last week, he was told when to appear, where to appear, so he should be here. I would request to not waive his presence because of that. And again, it's just, at exam, I would be requesting his bond be looked at again anyways. And the fact that he's not here today, I think is a concern for the people.
Your Honor, if I just may respond briefly, as the prosecutor was speaking, a call was coming in from Mr. Attard. So if I can have a couple minutes, I'll call him back and see why he's not on Zoom.
We'll pass this matter briefly. Thank you, sir.
Thank you, Judge.
Good morning, Mr. Nunley.
Good morning, Judge. How are you today?
I am super. How are you?
Doing good, doing good.
You're here for Macris?
Yeah, that's it.
I don't know whether or not I've seen.
I don't see her either. I can mute and
Okay.
try to call her and see.
Thank you.
Okay.
Mr. Scully, I don't think that we have seen your attorney this morning. I don't recall seeing Ms. Kirkland.
Not yet.
Okay.
Hi, yes. Hi, good morning, Your Honor.
Good morning, sir. I'm just letting you know that we see you. You're checked in. We just haven't seen your attorney yet this morning.
Yes, ma'am. Okay, thank you. I'll wait.
You're welcome. Mr. Boyer, Ms. Nelson, did you need to speak to Mr. Boyer or have you already done so?
We've already spoken, Your Honor.
Thank you. It will be Sutton Attard and then Boyer. Jamil Kuja,
Yes, hi, good morning, Your Honor.
good morning. What are you here for?
I have a Luther Gonzalez Hall. I'm sorry, I know it was a 9:15 and I was waiting in Judge Green's waiting room.
Your client, I thought I just saw them. I thought I saw them walking around.
He was on.
I saw him and I didn't recognize your name and you don't have a P number or case name, so I didn't realize you're an attorney. If you could reach out and get him back, I know that I saw him because he's walking around on the phone outside.
I'll get him back on. If the prosecutor's available, for me to have a breakout room with her. Then
There
I'll
are
get him back.
there are 3 cases that are ready, so I'll call them with the prosecutor and then I'll put you in where you can get your client back on.
I'll get him
Thanks.
back on. Thank you, Judge.
Oh, Miss Kirkland, wonderful.
Hey, Jeff, do you know that there's somebody in your meeting room?
I was just gonna check.
Yep.
Thank you, ma'am.
You're welcome.
Your Honor, on Attard. You got a little
Yes,
situation.
sir. Is there, well, the case isn't called. Give me
Okay, I'm
one
sorry.
moment. That's okay. Ms. Moisezian is still here. Is this something you need to discuss with her? Or is this something you're putting on the record?
Well, I could talk with her. To inform the court, I made contact and Wayne County Sheriff is there now because the victim's at that location.
Let's
So-
recall 220607 FY, State of Michigan versus Matthew Attard. The court already has your appearances. What's the issue, sir?
Your Honor, I had contact with Mr. Attard and then a deputy from the Wayne County Sheriff's came on. They're at the location. They said the victim is with the defendant. I assume some sort of arrest is being made. So I just asked if we can put this over, give the prosecutor a chance to look into it and then also myself.
I guess the question I have before the prosecutor responds, sir, is there's a no contact order. So it matters to the court if the victim went to the defendant or the defendant went to the victim. Before you answer that, Ms. Moisezian, what were you about to say, ma'am?
Judge, honestly, there were concerns of contact from the defendant to the victim, which is why I had requested that the Wayne County Sheriff's Department look into that contact. I was not aware up until now that he was actually arrested or they're present with her there. But again, this goes to my initial statement. There's a lot of serious concerns with Mr. Attard and his violations of this bond as well, or violations with a no contact order and the safety of the complainant. So if this fact is true, then I would likely be requesting some sort of emergency bond violation hearing to address that no contact order violation.
In the interim, in as much as this appears to be an evolving situation, the notation in the file is that the complainant is with the defendant and Wayne County Sheriffs are involved. We can put this matter over for a week for the prosecutor to have some time to look into it, and Mr. Gazicki, for you to have an opportunity to maybe make additional contact with your client or some representative for your client. And if there's something you need to address next week, we can do it at that time. Mary Ann, the time for the 12th?
9:45.
Wednesday, October 12, 2022 at 9:45, back hearing number 1. If there is some information or development that the court needs to be made aware of in the interim, please do not hesitate to contact the court's criminal department, and we will get the matter scheduled, addressed, or noted in the file appropriately. Anything else on behalf of the people?
Judge, just one last comment in regards to discovery. I just wanted the record to reflect that discovery was submitted in total, including the medical reports that I was waiting for. So I hope that defense counsel has everything. That was why it was originally adjourned for today, was to make sure he had all of discovery. So I just wanted to put that on the record as well.
When was the medical records forwarded?
It was sent yesterday.
Okay, I haven't looked at emails. All right.
Anything else on behalf of Mr. Attard?
No, Your Honor, I think not.
Thank you,
Thank
Judge.
you. This is a recall of 220054FY, State of Michigan versus Stephanie Sutton.
Good morning, Your Honor. Bryn Bailey on behalf of the people, P84009.
Good morning, Your Honor. If it please the court, Attorney Sharon Jones, P number 57113, on behalf of Stephanie Sutton, who is present by Zoom.
Good morning, Your
Sutton,
Honor.
Thank you. State your name for me, ma'am.
Stephanie Sutton.
Thank you. Today's the day and time set for the PCC in this matter. Ms. Jones, how are we proceeding?
Your Honor, my client has decided to avail herself of the offer from the prosecutor's office and will be tendering a plea to attempt resisting and obstructing with a 1-year probation requested.
Anything else, Ms. Bailey?
No, Your Honor, that is the extent of the people's offer. That is the only charge that Ms. Sutton is charged with.
Thank you. Ms. Sutton, raise your right hand for me, ma'am. Do you swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you, ma'am. Ma'am, you've had the opportunity to discuss this case with your attorney this morning,
Yes, I have.
and you understand that if the court accepts your plea of guilty to the added count of attempting, resisting, obstructing, assaulting police officer, you will not have a trial of any kind in this matter?
Yes, ma'am.
You will not have the opportunity to present witnesses on your own behalf or see and cross-examine witnesses put forth by the prosecutor.
Yes, ma'am.
And ma'am, you're entering this plea freely and voluntarily?
I am.
You haven't been threatened in any way, promised anything to get you to plead guilty?
No, ma'am.
I'm sorry, Ms. Sutton, before I ask you any other questions, Ms. Jones, I don't recall if we've had this conversation before. I wanted to disclose on you before I complete your client's plea that I am married to an elected official in Van Buren Township. I make that disclosure as I'm looking on the register of actions and I see that Van Buren is the issuing agency. My husband would not have any idea that Ms. Sutton's case was scheduled today. He's not involved in the day-to-day operations of the Van Buren Township Public Safety Department and would not have any impact or any concern or knowledge about the handling of this case this morning. Knowing that, ma'am, do you still wish to proceed with the plea this morning, or would you like to have this matter rescheduled?
We're fine, Your Honor, with that.
Thank you.
We will.
Ms. Sutton, my next question to you is, are you pleading guilty because you are in fact guilty?
Yes, ma'am.
Ma'am, is it true that on February 19, 2021 in Van Buren Township, which is County of Wayne, State of Michigan, you did attempt to assault, resist, or obstruct a police officer, being that you did attempt to assault, batter, wound, resist, obstruct, or oppose or endanger Officer Fidel, a police officer of Van Buren Township that you knew or had reason to know was performing his duties?
Yes, ma'am.
Ms. Jones, would you like to inquire any further of your client?
And did you do that by attempting to move away from the officer or run away from the officer?
Yes. The person I was
further-
with, sorry.
Thank you. I have no further questions, Your Honor. I'm satisfied.
Satisfied, Ms. Bailey?
Yes, Your Honor, I am.
Ms. Sutton, the court accepts your plea of guilty to attempt resisting, obstructing, assaulting police officer. The original charge is dismissed. Ms. Jones, from your perspective, is there any reason to refer this matter to the probation department, or are you ready to proceed to sentencing this morning?
We're ready to proceed, Your Honor. And I would like the court to know that my client does have 9 months of sobriety. She's been turning her life around. And she is in a recovery program with a GPS tether through 14B District Court. And so we were hoping to avoid anything that might be duplicative. If the court might consider non-reporting probation, since she already is reporting through 14B District Court.
Well, Ms. Jones, based on that, what I would like to do is to refer the matter to probation, not for a sentence recommendation, but so that they can confirm her, Ms. Sutton's 14B sentence, to make sure that we are not duplicating any of what she's already submitting to.
That would be
they
great,
should
Your
be
Honor.
able- They should be able to get that back up to courtroom 1 for sentencing in relatively short order. So Ms. Sutton, what will happen is the probation department will reach out to you at the phone number you confirmed and email you confirmed this morning. They'll reach out to the 14B and confirm what your sentence is with them. And we will schedule you to come back here for sentencing that will reflect the comments made by the prosecutor this morning regarding probation and any other terms that would be sufficient to keep you from reappearing or reoffending in this court, okay?
Okay.
Anything else on behalf of the people?
No, Your Honor.
Anything else on behalf of the defendant?
No, Your Honor.
Thank you. Ms. Sutton, I will see you at your sentencing date, ma'am. Have a good day.
Excuse me, what is my sentencing date?
At the probation department will
Oh.
schedule it.
Okay, thank you.
You're so welcome. Have a good
Have a
day.
good day.
Have a
Thank
good day,
you.
everyone.
Ms. Nelson, are you ready with Mr. Boyer?
Yes, Your Honor.
This is 220540 FD. This is State of Michigan versus Justin Lee Boyer. Ma'am, you're not smoking in the courtroom. You can turn your video off or you can stop smoking, please. My apologies to the attorneys in the Boyer matter, your appearances.
Morning, Your Honor. Bryn Bailey on behalf of the people, P84009.
Good morning, Your Honor. Sophia Nelson of Neighborhood Defender Service, P77960, on behalf of Mr. Boyer, who is present via Zoom. Mr. Boyer, can you please state your name for the record?
Justin Boyer.
Thank you. Today is the day and time set for the adjourned PCC. Ms. Nelson, how are we proceeding?
Your Honor, we are seeking a misdemeanor resolution in this case. We're working on developing some mitigation to give to Gary Bresnahan. However, I do think it would be appropriate to set this for exam, but far out in case we cannot resolve the case, we would proceed to an exam.
Is discovery complete, ma'am?
Yes, Bryn gave a colleague of mine a CD of all the digital in this case. I haven't obtained it yet from him, but I will.
That is correct, Your Honor. Last week I gave it to Mr. Bicker.
Our next date is 11/23/2022. If the parties believe that this matter will reach a resolution, I would piggyback it on an existing exam schedule, if that makes sense to you.
Yeah, the 23rd should give us enough time, Your Honor.
Mary Ann, I'm sorry. On the
Yes.
23rd of November, we'll set Mr. Boyer on at the 12:30 since Ms. Nelson and Ms. Bailey seemed to be moving towards a resolution, and we'll do a plea, fingers crossed at that time, but we'll schedule it as a exam, live exam on the 23rd of November, 12:30 p.m. here in courtroom number 1 at 34th District Court. Anything else, Ms. Bailey?
No, Your Honor, nothing further from the people.
Anything else on behalf of Mr. Boyer?
No, Your Honor, thank you.
Thank you. Mr. Boyer, I'll see you here on November 23rd unless the attorneys reach a resolution before that time, okay?
Okay,
Thank you.
thank you.
Ms. Kirkland, are you ready with Mr. Scully?
Yes, Your Honor.
This is 220529FY. This is State of Michigan versus Gregory Martin Scully. Your appearances, please.
Good morning, Your Honor. Bryn Bailey on behalf of the people, P84009.
Good morning, Your Honor. Neighborhood Defender Service by Kashava Kirkland on behalf of Mr. Scully, P84015.
And good morning,
Scully,
Greg
state your
Scully.
name. Thank you, sir. Today is the
Yes,
day and
ma'am.
time set for the adjourned PCC in this matter. Ms. Kirkland, how are we proceeding?
Your Honor, at this time, I still have not received digital discovery, so I just asked for that to be turned over again.
Ms. Bailey, would you need 1 week, 2 week, 3 week
Your
adjournment?
Honor, just let me check. I know I sent out the request. And it looks like I did get it all back. I just haven't been able to share it with Miss Kirkland yet. I can get it to her by the end of the hour.
Okay, Your Honor, I don't mind setting it for exam if I can get it today.
My question will be to you, Ms. Kirkland. Did you, there's two things. First, are you demanding an exam with discovery outstanding and incomplete?
Well, Your Honor, we've already adjourned this, I want to say twice, so I didn't want to keep adjourning it, especially if APA Bailey says that she has it all with her now and she could send it over to me today. If there were anything in there missing, then I'd reach out to her and ask for additional discovery.
The reason I asked that question is I know we've had this conversation before. If you demand the exam while discovery is not complete from your perspective, a reason for an adjournment of the exam will not be that discovery is not complete. That's number one. The second thing was that, and I know you've heard me say this before, but I'll say it again before we schedule Mr. Scully's exam. I am married to an elected official in Van Buren Township. I make that disclosure as Van Buren Township is the issuing agency in this matter. My husband would not have any idea that Mr. Scully's case was scheduled today. He's not involved in the day-to-day operations, wouldn't know any of the details of the case or have any bearing on what the court does in this matter. Knowing that, ma'am, and with the discovery, digital discovery issue, are you demanding an exam date? We're happy to give it to you this morning.
Your Honor, we'll ask for a 1 week adjournment on the PCT.
That adjourned PCC date will be October 12, 2022 at
10 o'clock.
At 10 a.m. That's back here in courtroom number 1 by Zoom. Mr. Scully, next Wednesday morning at 10 a.m. back here at the same Zoom ID. Okay, sir?
Yes, ma'am. Thank you, everyone. Have a great day.
You too. Thank you, Mr. Scully.
Bye-bye for now.
Ms. Bailey, did you speak to Attorney Kuja on Gonzalez Hall?
I have not had the opportunity yet, Your Honor, no.
Okay, before you go in there, I note that Ms. Janice Kuzub has been here for quite some time. This is 220659 SM. This is State of Michigan versus Alicia Kuzub. The matter was scheduled for a pretrial at 9:30. It's 10:34 by the court's clock. When the defendant was here previously.
Judge, I hate to interrupt you, but she is here and she's been waiting to talk to Mr. Bowditch.
Oh.
No, Your Honor. Well, Your Honor, Miss Bailey was going to talk to the alleged victim who is also present. And I'm waiting for the results of that conversation.
And I'll stop talking. I'll leave the bench. Miss Bailey can speak to both Attorney Kuja and follow up with her witness. If anything else comes ready.
Your
Court will
Honor,
resume.
I actually was just about to send Mr. Bowditch a message. And I think
And I won't leave because I see that Ms. Macris is here too, and Mr. Nunley was here for that case.
Agreed, Miss Bailey. Thank you. We are ready on COSIP, Your Honor.
Mr. Bowditch? Respectfully, we're not ready when the defendant's not in the room. If you want to go get her and bring her out, or we can force her out. And there we are. This is 220659 SM. This is State of Michigan versus Alicia Marie Kuzup. Appearances, please.
good morning, Your Honor. Bryn Bailey on behalf of the people, P84009. Jeff, you're muted.
Muted, Mr. Bowditch.
Your Honor, for the record, Jeffrey Bowditch appearing on behalf of and with Ms. Kozub. Ms. Kozub, could you tell the judge your name for the record, please?
Alicia Kozub.
Thank you, ma'am. Your Honor, I believe the prosecutor wishes to dismiss in this matter. Defense has no objections.
Your Honor, the people have had an opportunity to speak with the complaining witness, victim in this matter, Janice Kuzup, who has indicated to this prosecutor, Your Honor, that she does not wish to cooperate with prosecution, that she does not want anything to move forward, and that she will not appear for any future court dates to testify. I have explained to her the repercussions of this case being dismissed here today, and she still does not wish to proceed.
We would put forward a motion to dismiss, Your Honor.
Ms. Janice Kuzup, were you able to hear the prosecutor's comments just now?
Yes, Your Honor.
And is your intention not to cooperate with the prosecution further?
That's correct.
Understanding that this case will be dismissed.
Yes, Your Honor.
The defense motion to dismiss is granted. This case is hereby dismissed.
Thank you, Your Honor.
Anything else on behalf of the people?
No, Your Honor.
Anything else on behalf of the defendant?
Will the no contact order be dropped?
I'm sorry?
The no contact or everything will be dropped?
It will be, because the case is dismissed. The court no longer has any jurisdiction over Ms. Alicia Kuzup. Ma'am, you are free to go. Thank you for joining this morning.
Thank you.
Thank you. Thank you.
Could somebody put me into a breakout room with Ms. Bailey? She went over there to meet me, but I don't have the ability to put myself there. Thank you. I think maybe I was put into the wrong room, Marianne. I was alone in there. I was so scared.
Oh, I'm sorry. Here, I'm gonna make you co-host and I'm gonna put you in there.
All right, thank you.
You're welcome.
You went and came back already, Mr. Nunley?
She was in there with another attorney, so I wanted to give him some privacy. So I'm just kind of watching the breakout rooms for when the other one's done. I'm gonna jump back in.
You should have stayed in there and maybe sped things up a little bit.
I could be the Court of Appeals. If they can't agree on something, they could just come for immediate review.
Mary Ann, while we're waiting for the return, we had 22 RP 03528 A and B. These were State of Michigan versus Marcel Green. Matters were scheduled for arraignment pretrial at 8:45. It's now 10:49 by the court's clock. Defendant having failed to appear, the A file misdemeanor will be set for show cause and the civil infraction will be defaulted. This is 220639 SM. This is State of Michigan versus Lakia Brookins. This matter was scheduled for remote arraignment pretrial at 9 a.m. It is now 10:50 a.m. by the court's clock. There is no one by the last name of Brookins in the main session. No unidentified persons in the court's virtual breakout or in the waiting room. Based on the defendant's failure to appear as directed by the court, matter will be set for show cause. These are 22BL 00648 A and B. These are State of Michigan versus Miguel Jenkins. These matters were scheduled for pre-hearing and arraignment pretrial at 9:15. It is now 10:50 by the court's clock. Defendant having failed to appear. The B file civil infraction will be deemed in default. The A file misdemeanor will be set for show cause. Good morning again, Ms. Morrisfield.
Good morning, Judge, and how are you?
I am super. How are you?
I am just fine.
So it appears that the court garden has yielded a pretty cute carrot. It's about maybe 4 inches long.
Oh, how do you know? Were you out there picking? Or somebody brought it to you?
Somebody sent me a picture,
Oh, nice.
and the sunflowers still look nice.
They do. Are you talking about by the lunchroom?
Mhm.
Yeah, those look. Who's planted those?
I don't know. I don't go down there. And so I forgot they were even out there. I knew they were growing carrots in pots, but I haven't seen them.
Because those sunflowers are really nice when you pass by.
Why are your eyes not on the road?
It's because I'm coming to a stop before I get to Wayne Road when I'm pulling out like by the library.
If that's your story.
I'm sticking to it.
So you saw the message that said return to the main session.
I did.
Okay.
Mm-hmm.
I'm glad to know that that feature works since you're the only one that responded to it.
The other two are deep in speak.
I understand that, but there's a 9:15 case, 9:15 scheduled case that is waiting to be called.
Oh.
And silly me. trying to get up and take a quick walk around the building before the 12 o'clock cases start.
That would be nice because then you can go see the sunflowers.
I am, that's my goal. Quick run downstairs to check out the sunflower and take a selfie with the carrot and see what else happens this morning. Or maybe somebody will bring it up here and I'll put it in the corner so everybody can see it this afternoon. I'll make a big pedestal for it or something.
Not a lot of MIDC work today.
No, the morning docket looked a little sparse. But there's 7 exams scheduled, so not 7. Yeah, 7. This is 22 HR 07048 A and B. These are State of Michigan versus Luther Gonzalez Hall. May I have your appearances, please?
Good morning, Your Honor. Bryn Bailey on behalf of the people, P84009.
Oh. Did we lose Mr.?
Oh, I thought I saw Mr. Kuja.
He's been here. Oh, Mr. Gonzalez Hall? Oh my goodness. He's been here all this time.
You know, Judge, earlier he kind of fell out and came back, so maybe he's having an issue.
Mr. Gonzalez Hall, your attorney has left for momentarily. As soon as he reappears, we'll get your case recalled, okay? And I just saw your formal hearing arrive. Sorry. And Mr. French is now here too.
Okay, I'm sorry. I just unmuted it.
You're fine.
Couldn't
As soon
figure
as
it out.
Mr. Kuja returns, we'll get you called, sir.
Okay, thank you.
Good morning, Mr. French. Did you need to speak to your client?
I need to speak with the prosecutor first, please.
We're almost finished with our morning docket. Give me a moment. We have 2 more cases scheduled.
Okay, and good morning, Judge.
Good morning, sir. Oh, here he is. Mr. Kuja, are we ready on Gonzalez Hall?
Yes, Judge, we are. Sorry, I got
This is
disconnected.
So Mary Ann told me you were having some issues. This is 22 HR 07048 A and B. These are State of Michigan versus Luther Gonzalez Hall. May I have your appearances, please?
Good morning, Your Honor. Bryn Bailey on behalf of the people, P84009.
Excuse me.
And good morning, Your Honor. Jamil Kuja, P71963, appearing on behalf of Luther Gonzalez Hall.
Mr. Gonzalez Hall, state your name for me, please, sir.
Luther Diablo Gonzalez Hall.
Thank you. Today's the day and time set for the pre-trials in these matters. Mr. Kuja, how are we proceeding?
I didn't hear what you said, Judge.
I'm sorry?
Did you? I wasn't sure if you were addressing me. I couldn't hear you.
My question to you was, today is the day and time set for the pre-trials in these matters. How are we proceeding this morning?
Judge, we're asking to set the matter for a bench trial in person.
Is discovery complete, sir?
Yes.
Mary Ann, will we do that at the end of the 16th? Or, nope. On the 23rd?
That's what I'm looking at right now.
Ooh. Ooh.
You have an 11 on the 16th.
I have space at 11 on the 16th?
Yes, you do.
Oh. Mr. Kuchar, are you available on November 16th at 11?
I am. You don't have anything this month, though, Judge? No.
I only have the prosecutor 2 weeks out of 6, so no, and I can't piggyback on somebody else's date. If I could do it sooner, I would. November
right.
16th, 2022 at 11 a.m. live here in person, courtroom number 1 at the 34th District Court in Romulus, Mr. Gonzalez Hall, November 16th at 11 a.m., sir. Anything else on behalf of the people?
No, Your Honor.
Oh, yeah.
Anything else on behalf of the
Thank you, Your Honor.
I'll see you
Oh,
then.
yeah.
Thank you.
Thank you. Bye.
This is 220650 SM, State of Michigan versus Angela Marie Macris. May I have your appearances, please?
Good morning, Your Honor. Bryn Bailey on behalf of the people, P84009.
Royce Nunley appearing on behalf of the defendant.
Angela Macros.
Thank you. Today is the day and time set for the pretrial in this matter. Mr. Nunley, how are we proceeding?
At this time, we do have an agreement to amend the bond condition to allow contact between the defendant and her 2 minor daughters who were the subject of this matter. And beyond the amendment of the bond order, we are asking for an adjournment for a date sometime after November 4th. Ms. Macris has an issue, a probation issue that is happening on November 4th in 3rd Circuit. And I would like to talk to her after she goes to that hearing and hopefully be able to proceed at the next court date.
That would be November the 9th.
November 9th, okay.
I'm looking
for Mary.
Yeah, I'm looking.
I know. I was about to say, just wait for Mary Ann to get a time. That's a little far out.
At 9 o'clock
And that is,
with Judge Green.
We'll adjourn the PCC in this matter to November 19, 2022 at 9 a.m. in courtroom number 3 by Zoom with Judge Green. The parties have stipulated to amend the bond conditions to allow contact with the complainants in this matter, that being Ava, last name is Aniol, and Alyssa, Aniol. Anything else on behalf of the people?
No, Your Honor.
Anything else on behalf of the defendant?
No, Your Honor, that's all.
Thank you, ma'am. November 19th at 9 a.m. virtual courtroom with Judge Green. Have a good day.
Thank you, Your Honor. Have a good day.
Thanks, everybody.
Thank you.
See
And then Ms. Bailey in with
You,
Mr.
Bryce.
French. And then those
Yep.
are the only, we've concluded the morning's docket, Mr. Bowditch.
Thank you, Your Honor.
Thank you,
No.
sir. Have a good day.
Your Honor, you want me to hang out for a minute?
No, I've already called the other cases and
All right.
they're either show caused or defaulted. Thank you.
Thank you, Your Honor. Thanks, everybody.
See you, Jeff.
All right, I'm done too, Judge.
Thanks, Heather.
Okay,
Thank
I'll
you're
see you
welcome.
Bye,
shortly,
Heather.
Judge,
Thank you.
for
Bye. Yep.
live exam. I'll see
Take
you
care,
in a
Ms.
minute,
Dennis.
Gran.
See you guys in a minute.
Okay.
That's not what I want to do. There we are. Did she used to watch the Brady Bunch?
I used to love that.
Did they ever show Alice's room?
That's such a random question. Oh my God, what are you thinking out there?
Look,
I don't-
lady.
I do not remember that.
I saw a headline about Alice's secret something, and I don't click on stuff like that. I just kind of go past it. But then I started thinking, Alice is there all the time. She goes back between the range and I think it's the refrigerator over there, down the little hallway. And I'm assuming that's her room, laundry room kind of thing. And I don't remember. And then carrying on with Sam that whole time, I don't remember if they ever went back there.
I bet if you, I can't wait till you can come in my office.
And this is why I cannot remember to bring my pen out on the bench because I'm worried about what Alice's room looks like. Are we ready on Ms. Johnson?
Yes, Your Honor.
Yes, Your Honor.
This is 22L552986OI. This is Wayne County Sheriff's versus Nicolette Johnson. And before I thank you, your appearances, please.
Good morning, Your Honor. Bryn Bailey on behalf of the people, P84009.
Good morning, Your Honor. Good to see everybody, albeit by Zoom. Ronald French appearing on behalf of Ms. Johnson.
And ma'am, your name for the record?
I'm sorry, Nicolette Johnson.
You're fine, Ms. Johnson. Today is the day and time set for the formal hearing. We had adjourned this matter previously as Mr. French was in a trial somewhere else. Matter scheduled for formal hearing this morning. Mr. French, how are we proceeding?
Your Honor, I believe the prosecution is going to be gracious enough to nullo this one and give us a dismissal. They're not prepared to move forward. We are. So we are thankful and for the graciousness, and we have no objections to moving for dismissal.
That is correct.
I'm sorry, Ms. Bailey.
I was just going to say that that was correct, Your Honor. The trooper has not appeared.
Thank you. Ms. Johnson, this case is hereby dismissed. Ma'am, you have a wonderful afternoon.
Yes, ma'am. Thank you very much. Thank you, attorney, prosecutor. Thank you very much.
Thank
You're
you.
welcome. Have a good day, everybody.
You too, sir. And Ms. Bailey, I'm sure you need to walk around and stretch and whatnot. Looks like we're scheduled for 11:30 with Ms. James and Mr. Davis.
That is correct, Your Honor. And then if I
you,
could just get the 315s whenever there's a moment, I'd appreciate it.
I have them here. No one's come in to check on me, which I'll take up with the officers again, but I'll send them out to you in just a moment, okay?
Thank you.
Thank you. He's not ready. Mary Ann? Oh, she still has her thing on from.
Pardon me, Judge. I just talked to the prosecutor. This is already 10 minutes into it. I asked her if we have anything to explain. This is what I'm asking, Judge, how much time do you want?
5 minutes.
Thank you.
It's 15 minutes, you know, so.
Thank you.
Okay. Just a few minutes.
report this report now in session. All rise, the report this report now in session. Judge Martin presiding.
Nope, she's here. I see her coming. Ms. James? This is 220490 FY, State of Michigan versus Raina James. May I have your appearances, please?
Good morning, Your Honor. Bryn Bailey on behalf of the people, P84009.
Hey, good morning, Your Honor. Maurice Davis, P76203, here with Raina James, President to my right. James, state your name.
Raina James.
Thank you. Today is the day and time set for the in-person preliminary examination. In this matter, there is count 1, weapons carrying concealed, count 2, assault with dangerous weapon, count 3, weapons felony firearm. Are the people ready to proceed?
Your Honor, I will note that the people have one of the officers here, the detective, the officer in charge, Detective Mike Long, got off the phone about 3-4 minutes ago with the complaining witness who indicated that he is on his way and is running late. However, if the court wishes to start the exam, I can call Officer King.
So the answer to the question is yes, the people are ready to proceed.
Yes, I'm just letting Your Honor know that I'm still awaiting one witness.
Understood. Defense ready to proceed.
Ready to proceed, Judge.
Any preliminary matters?
No, Your Honor. nothing
Any
to-
preliminary matters, Mr. Davis?
Let's move to sequester witnesses. One second.
Anything else, Mr. Davis? Thank you. You may be seated, Ms. James.
I would just ask for an exception for my officer in charge.
Absolutely.
Your Honor, at this time, the people would call Officer Mark King.
Still morning. Good morning, sir.
Good morning, ma'am.
State your first and last name and then spell them for the record, please.
Mark, M-A-R-K, King, K-I-N-G.
Raise your right hand. Do you swear a firm testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you much. Come up here, please. Have a seat in the black chair that's closest to me. My secretary will be taking down your testimony. If for some reason she's unable to hear you, I'll ask you to either raise your voice or pull your microphone closer, okay?
Yes, ma'am.
Your witness, Ms. Bailey.
Thank you, Your Honor. Good morning.
Good morning.
Please restate your name for the record.
Officer Mark King,
And Officer King, how are you currently employed?
I'm a police officer, Van Buren Township Police Department,
How long have you been employed with Van Buren?
about 8.5 years.
Were you a police officer anywhere else before that?
I was City of Fraser for about 28 years,
So in total, you've been a police officer for 30.
almost 37 years.
Were you employed and working for Van Buren on July 3rd, 2022?
I was.
Were you by yourself or with a partner?
I ride in a one officer unit, but I did have a backup on this call. It was Officer Fidel.
Officer Fidel?
Yes,
Could you spell Fidel for me?
F-E-D-E-L.
And did your duties, was the unit that you were in fully or semi-marked?
Fully marked.
Were you in full or modified uniform?
I was in full uniform.
What does that look like?
Very similar to the uniform I'm wearing today, except with the exterior vest and a gun belt attached.
And it has your name and your badge number and all of the identifying marks of a police officer?
Yes, ma'am.
All right.
Ms.
Now-
Bailey,
Yes, ma'am.
I'm going to stop you for one moment. Mr. Davis, so far, all that Ms. Bailey has done is identify Officer King and take his brief professional history. You were retained, I believe, the day before this exam was originally scheduled. We adjourned it to today, and there is no notation in the file that I disclosed to you that I'm married to an elected official from Van Buren Township. I know you've had other cases with me where Van Buren Township Public Safety Department was the issuing agency. My husband is not involved in the day-to-day operations of the Public Safety Department. He wouldn't have any idea that this case was scheduled today or any of the details of this case, and would not impact any decision that the court makes this morning. Do you need time to confer with your client before we proceed with the testimony?
No, Judge, I'm ready to proceed.
Thank you. Sorry for that interruption. Mr. Davis, I just didn't have a notation that we had this conversation back on August the 24th. Ms. Bailey, if you want to resume your questioning, please.
Thank you. Did your duties as a Van Buren police officer take you to 42,034 Freeport Court?
Yeah, 42034 Freeport Court.
Is that in Van Buren,
It is. I was dispatched a call there.
Wayne County?
Yes, ma'am.
And do you recall around what time this call was?
5:30 PM.
And when you arrived, what, if anything, did you observe?
There is a party occurring at the residence.
Are you reviewing your report?
No,
Okay.
I'm just looking down right now. There's a party at the residence. I met with the victim complainant and one of the witnesses out in front of the residence.
Okay. And as a result of your conversations with them, what, if anything, did you do next?
I conducted an investigation to a police assault CCW complaint, and Officer Fidel secured a weapon that was within the home.
Did you observe Officer Friedel recover this weapon?
I did not.
Did you speak to anyone aside from the complaining witness and other eyewitness?
I did. I spoke with several witnesses that were at the party. There's probably about 15 to 20 people at the party, but I spoke with, I think, 7 or 8 of them.
Did you, do you see anyone that you spoke with here in the courtroom today?
Yeah, I interviewed Ms. James after the fact at the station.
Okay, do you recall, was it the same day or a different day that you interviewed her?
It was the same day.
Do you recall around what time you interviewed her?
It was after I cleared the call. I don't know the exact time, approximately an hour and a half to 2 hours after initially responded.
And when you why did you interview Miss James at the station?
Because she had already left the scene when I was there, she was not there. So I called her on the phone to see if she'd come to the station for an interview, and she said that she would.
Okay, and she did come to the station.
She did.
All right, and what is, where is Miss James seated and what is she wearing?
She's seated next to her attorney. She's wearing the white and black coat with the blue, light blue lining.
Your Honor, let the record reflect that the witnesses identified the defendant.
Yes, ma'am.
Now, when you spoke to Miss James at the station, how did you begin that conversation?
When Ms. James came to the station, she was placed on arrest for probable cause on felonious assault and carrying concealed weapon. She was escorted back to the booking room, where I advised her of her constitutional rights for Miranda, and on a prescribed form, went over the form with her. Ms. James stated that she would waive her rights and she would speak with me about the incident.
So let's, when you went over Miss James's Miranda rights, is there a form that your department uses?
There is.
And is this a form that is filled out with every person who is arrested and then subsequently interviewed?
Yes, ma'am.
Would you recognize this form if I showed it to you?
I would.
Your Honor, let the record reflect that I have showed Mr. Davis a copy of the People's Intended One.
Yes, ma'am.
Permission to approach?
Yes, ma'am.
Officer, what have I just handed you?
It's our Miranda rights waiver on the prescribed form for Van Buren Township Police.
And is it a fair and accurate representation of the form that you went over with Miss James?
Yes, ma'am.
Do you see your signature?
I do.
Do you see Miss James's signature?
I do.
Has anything been changed or altered in any way, shape, or form?
Other than it's a copy of the original, no.
Your Honor, at this time, the people would move for the admission of the people's proposed one.
No, Judge.
It's received. Thank you.
Now, when you were going over the rights with Miss James, how do you know that she understood her Miranda rights?
I read the individual section of the Miranda rights waiver form, and basically I read it verbatim, said, before we ask you any questions, you must understand your rights, you have the right to remain silent. And I asked her if she understands that, she says yes, and I have her initial it. I read the next right down the line, says anything you say can will be used against you in court. Do you understand that? Yes,
Okay.
and then she initials that.
So did she initial all of the rights?
She did.
And do you know how long she was in custody before you began this interview?
It was shortly after she was taken into custody, so she was advised of her rights according to the form at 21:10, which would be 9:10 PM, and signed the form at 9:13 before the interview began.
Okay. And do you recall what time she came to the station?
I don't, but she, like I said, she was not at the station very long. I don't know if I can't remember if I was on the road and had to come into the station, or I don't know the exact time frame, how long she was there.
Okay.
It wouldn't have been very long.
So been less than an hour?
Oh, much less than an hour, yeah.
Okay. At any point during your interaction with Miss James, did she request use of a bathroom?
I don't recall.
What about water?
I don't believe so.
Food?
I don't believe so.
Did she ever ask to speak with her attorney?
No.
If she had asked for any of these things, would she have been given those things?
Yes, ma'am.
If she had indicated that she no longer wanted to speak with you, would you have terminated the interview?
Yes, ma'am.
Your Honor, at this time, I'm going to turn the witness over for voir dire of the voluntariness of the Miranda waiver.
Thank you.
Your Honor, at this time, I move that this court find that for preliminary examination purposes, that Ms. James did voluntarily and knowingly waive her Miranda rights.
No objection for exam purposes.
Thank you.
So after going through her Miranda statements with her, or her Miranda rights with her, you had a conversation with Ms. James.
Yeah, I conducted an interview.
Now, was this interview in a question answer format, or did you have her write out a statement?
It was question answer. She declined to write a witness statement.
So if I had a written statement from Ms. James, that would not be
Well,
hers.
then she did write a written statement. I'm in error there. ma'am.
Okay, so she did, so it was both question and answer format as well as a written statement?
Yeah, at the end of the question answer period, I often allow people that I interview to write out a written statement. They can either decline. I believe that, I thought that she had declined, but obviously she did not. So.
Now, would you recognize this statement if I showed it to you?
I would.
Mr. Davis, people proposed to.
Yes, ma'am.
Officer, what have I just handed you?
The statement on the Van Buren Township Police Department statement form completed by Raina James on 7/3/22 at 21:31 hours, which would be 9:31 PM, and completed at 9:53 PM.
Okay. And is it a fair and accurate representation of the form that you observed her fill out?
Yes, ma'am.
Did you sign this form?
I did not sign it, but my name is on the bottom.
Did you observe, is Miss James's signature on it?
It is.
Did you observe her sign it?
I did.
Aside from being a copy, has anything been changed or altered?
No, ma'am.
Your Honor, at this time, people would move for the admission of the people's proposed to.
Well, Judge, at this point, I'm going to object. There hasn't been anything else placed on the record as to why this is being admitted to, records. There presenting evidence that my client is being is herself. And I think there has to be something more that happen from another witness in order to establish why this is being presented. So far, we haven't had any evidence as to why this is just a blanket statement. My client sat on board and released all the statement that's being presented in all this evidence, but there's nothing to back up this statement.
What other witness would you propose be necessary to have your client's statement?
A victim, some evidence of a crime that she supposedly committed.
And Your Honor, as
I'm sorry. Were you finished, Mr. Davis? Oh, okay. I'm sorry, Ms. Bailey.
And Your Honor, as indicated at the beginning of the examination, my victim was running late. He is in fact here now. I made the decision to start the exam, going with what would have been my second witness first, so that we could start it. He is here and he will be testifying as to what occurred, which would lay the foundation that Mr. Davis is asking for. I can either continue with this witness, or we can pause him, bring in my victim, and do all of his testimony, and then finish with my direct examination and then the subsequent cross-examination of this witness after we've done it with the complaining witness.
I saw the person appear, and Mr. Davis, my question was going to be, do you want us to suspend Officer King's testimony and take this issue up regarding admission of the statement, or?
Well, if he's present now, we can take it.
Thank you. Peoples 2, the statement will be received.
Thank you. Now, Officer King, when you were speaking with the defendant, what, if anything, did you ask her about a potential weapon?
I basically asked her what happened at the residence, and she explained that she had a firearm on her person. She got into an argument with her uncle, and as a result, the weapon was pulled inside the residence.
Okay. Did she tell you what she did with the weapon after pulling it?
Basically, the weapon was taken from her by the people at the party and was not given back to her. It was secured in a location.
Did she tell you from where she pulled the gun?
Her pocket of her shorts that she was wearing.
Your Honor, I have no further questions for this witness at this time.
Thank you. Mr. Davis, your cross.
Yes. Officer, Ms. James indicated that she pointed the firearm high, is that correct?
That's what she indicated, yes, sir.
At no point did she ever indicate she pointed at any point, is that correct?
That's what she indicated, yes, sir.
Okay. In fact, she stated that she did not point at anything, is that correct?
That's correct.
Thank you. Any redirect?
No, no redirect. I would just ask to publish the people's 1 and 2.
Yes, ma'am. Thank you. Officer King, thank you for your testimony, sir. You may step down. Thank you, Officer Crover.
Thank you, Your Honor.
You're welcome, sir.
And Your Honor, at this time, the people would call Renal Anderson to the stand.
Mr. Anderson?
Yeah.
Good afternoon, sir. Come all the way up to this podium right here for me, please. Have you state your first and your last name and then spell them for the record, please.
Renell Anderson, RENELL
Raise if you can't raise your right, raise your left. I understand. Do you swear or affirm testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Thank you much. Come up here, please. Have a seat in the black chair that's closest to me. My secretary is taking down your testimony. If she can't hear you, I'll ask you to either raise your voice or pull the microphone closer, okay? Miss Bailey.
Thank you, Your Honor. Good morning. Could you please state your name for the record again?
Renell Anderson.
And Mr. Anderson, do you remember July 3rd, 2022?
I do.
And on that day, did you have occasion to be at 42,034 Freeport Court?
Yes.
Is that in Van Buren Township,
Yes.
Wayne County?
Yes.
What, if anything, is at that location?
What?
What, if anything, is at that location?
My home.
So you live there?
Yes.
On the 3rd of July of this year, were you at home alone or did you have people over?
People over there.
How many people did you have over?
23rd.
Did something happen while you were at home with those other 23 people on that day?
Yes.
Mr. Anderson, if you want to put your mask on, you can put your mask on, but your hand in front of your face, I think is affecting her ability to pick up your testimony, sir.
How did the incident start?
Ms. James was very disrespectful, jumped up from a picnic table from downstairs, my walkout, threw a plate in the air. It said, you. And then she took off up the hill.
Okay, so were you all outside at this point?
We had people in several locations. There were kids downstairs. There were people in our house on the main floor, mother-in-law, lots of people. I was in the kitchen, so when she took off with the attitude running up the hill, I said, good riddance, because she was not allowed to my home.
Okay, so I'm gonna stop you right there. Do you see Miss James here in the courtroom?
I do.
Could you please point to her and tell me something that she's wearing?
Aqua colored hoodie,
I'm so sorry.
aqua colored hoodie.
Okay. Your Honor, let the record reflect that the witness has identified the defendant.
Yes, ma'am.
So this hill that you observed the defendant running up, was it towards your house, away from your house, or something else?
Away from my house.
Okay. And how far away from where Miss James started before running up the house were you?
I was on the deck. She was on, we have a walkout that's down the hill. I was on the deck. She was down on the bottom.
Okay. So so did you tell her that she wasn't allowed at your home?
Prior to that day, she knew, her mother knew, and they were not to bring her child. My wife is raised that girl. My wife is the grandmother of 2 children that her mother was watching. So my wife wanted the grandkids to come over for the holiday. Excuse me?
He's making a legal argument. If you stop for one moment, the prosecutor will respond, and then I'll let you know whether or not you can answer that question, okay?
Your Honor, I'll move on.
Thank you.
So Miss James is leaving. Did she stop leaving and return to your home at some point?
No, when she flew off the handle and went up the hill, I was like, in my mind, good riddance. I went back in the kitchen.
Okay, so you went back into the kitchen. Did you say anything to her or anyone before going back into the kitchen?
No,
Okay, so you return to the kitchen. What happens next?
I was over the sink, my back towards, my house is laid out. I was over the sink.
With your back towards the door that leads out to the deck?
Dining room, great room, and my front door. All of that's behind me.
Okay, and where is the entrance and exit to the deck in relation to where
To
you
my
are?
left.
To your left, okay. So you're washing dishes at the sink?
No, I was doing something because I was getting ready to eat. So
Okay,
something.
so you were in the kitchen, deck was on your left, your back, your front door, and the majority of your house are behind you.
Mhm.
Did something happen that drew your attention?
Yeah, she came in with a lot of talk.
Okay, what door did she come in?
The front door, which is behind me.
Okay, so you said that she came in with a lot of talk. What do you mean by a lot of talk?
What people say when they have some ill intentions. You came talking with me with this gun on. When I turned around, I saw the gun.
Okay, so where did you see the gun?
It was in her hand. I'm over the sink. I turned around. She came through my dining room talking about what she was about to do with this gun that she has pointed at me.
Okay, so which hand did she have it in?
I think it was the left.
You think it was her
I
left
think.
hand?
I'm not, it's a little uncertain.
Okay. So you said she was talking about what she was gonna do. Can you be more specific about what exactly
I
she was
will
saying?
kill you. I will do this. You're not that guy, whatever. All this big talk like a guy would say, if there was something, some threat was made to them. I had no weapons on my person. She came with all the talk about somebody that got something from me.
Okay, so she said that she was gonna kill you.
That's her intent. She got a pistol right at me.
Did she say that?
Yes, she did.
Okay, how many times did she say that?
It's been over 2 months. I'm not sure. It was a lot of ranting. It was loud enough and numerous enough for people to hear it and come in from the deck from behind her.
Okay. Where on your body was it pointed?
Where what?
Where on your body was the gun pointed?
Somewhere in this range, she had it sideways, like she must watch TV, doing like this. So
Okay, so
there's
let
a-
the record reflect that the witness he has taken his left arm, I'm not sure if that's because his right arm isn't as splayed, but he has taken his left arm, held it out straight in front of him with the palm facing down, appearing to be holding an item in his hand and is waving it up and down.
Yes, ma'am.
So how close did she get to you with the gun?
There was there's an island in between us that's maybe it's 12 feet from, there's a granite island in the middle between us, the only thing that's between us,
Okay, so she was about 12 feet away from you?
somewhere in that
Okay.
region.
And what happened next?
People heard her, came in from behind and attempted to disarm her, and it took more than one. My
Took more
wife-
than one person?
To disarm her.
Okay,
My
do you know?
wife, my wife was the first in, and she had to literally, she said, had to peel her fingers back to get the pistol out of her hand.
How many people came in to assist, to?
Roughly three.
Roughly three, do you remember who they were?
Yeah, there was, I guess he's a friend of, one of the family's friends, I'm not sure, Shelton's cousin, I don't remember his name. My wife and Shirley, the last name is. Let's say my wife, one of my wife's cousins, cousin of her too, and a non-family member.
Okay. Were they able to get the gun away from the defendant?
My wife peeled her fingers back, took it. They walked her to the door.
And when you say they walked to the door,
Whomever, the two people that had it, they grabbed it, they had to, how you would take someone, get them out of there.
so those two other people whose names you can't recall at this point, one of them was Shirley, and then the other one whose name you don't remember, they took the defendant to the front door or the back door?
Front door.
The front door, okay. So after they take the defendant to the front door, what happens next?
There's a lot of talk, they get her in the car, she starts to pull down the street, and I'm like thinking about it. So I said, no, I'm gonna get her tags, because the way they live, I don't know who that big vehicle was registered to, but it was my intent, when she decided, oh, now it hit her that she was wrong and went to drive away, I caught the tag number, but by that point, I mean, she was gone. So I got enough of it, and I called 911.
Okay, so you called the police to report what had happened.
Mhm.
Is that a yes?
Yes,
And at some point, did the police arrive?
yes,
Did you speak with the police when they arrived?
I did.
Okay. At any point during this party, were you having an argument with the defendant?
It was an argument, it was a statement. She escalated to an argument. Her child misbehaved. That's how I came out the kitchen to the deck to tell her and her mother about it, because they knew their presence was really not welcome. That's why they were downstairs, away from the rest of the crowd.
So did you observed something that required the defendant's attention regarding her son?
Yes,
And you went to speak with her about it?
yes,
Were you still up on the deck when you went to speak with her
Yes.
about it? Okay. Was she on the deck too?
no,
Okay. So were you having this conversation with you up on the deck and her beneath the deck?
yes.
Okay. Is that when she got angry and stormed off?
Well, that's when she jumped up and flipped her paper table, threw food over the same cousin who, no, it's different. When she jumped up, yes.
Okay. So you say it wasn't an argument, but she made it one.
Yes.
How did she make it one?
I leaned over the deck when I saw what happened. See, when I'm at the sink doing what I was doing, I'm watching her son because he's done a few things. So I'm watching out my kitchen window and I saw him, they're kids. But he made a gesture. We had some blow up things around him for the kids to play bump around, air bubbles.
Okay.
So I saw him take that off and lunge at my neighbor's son. And I'm like, that's it. So I went out the deck to tell her what happened, because I knew they were at the bottom. When I got there, that little boy had run, this is a matter of seconds. He had run from a neighbor's area outside their walkout where I saw it, to his mother and his grandmother. They are such a mess. He had in that few number of seconds, it's less than 15. had
Okay,
to
so
be.
you observed the defendant's son talking.
Oh, I
with-
shouted out the window at him.
I'm sorry?
I shouted out the window when I saw what he was doing. So he took off running up under my deck to get to them. In that short period of time, he told the mother and the grandmother something about what he did not do. It was to the point when I came, he ran from there under the deck over here. So I'm right here after I shout, hey! So I shout, he heard the voice because he knows my tone. I have it the same way everybody's arrogant like that. In that short time, he ran seconds. He ran from the
occurrence of his threat to my neighbor's child to my walkout where his mother and grandmother were, and told him a version of something in another few seconds. This is how cunning and
So
deceitful.
then you observe him talking to this child, talking to the defendant and the defendant's mother.
He ran, no, this is what happened. You have to see the picture. The picture is I saw him lunge out threatening motion to my neighbor's child.
Right.
I hollered at him, he runs from that occurrence over to up under the walkout where his parent and grandparent is. And he tells them something really quickly because I left and I was.
So just a second. I'm trying to get to the relevance, Your Honor.
Okay.
Is your objection is not really to Ms. Bailey's questioning, your objection is to the relevance of Mr. Anderson's response, correct? Okay. Mr. Anderson, I understand that you're trying to tell your story, but the prosecutor needs to ask it in pieces. So when she asks you a question, if you just respond to that piece, please.
Okay.
Thank you.
So the incident that you saw happen with the defendant's child, is that what started the argument?
Yes.
Okay. Okay, I have no further questions for this witness at this time.
Thank you. Mr. Davis.
Yes, Judge. We're having a family gathering in your home, is that correct?
Yes.
And what time did that gathering start?
Somewhere between 1 and 3. I think, see, the time is a little vague. I don't know because we started having people early so that they could leave early. Okay. No dead stopping.
So at some point, Ms. James arrived to your home, is that correct?
That's correct.
And how long had Ms. James been in your home before the incident you described occurred?
It was not long.
Minutes, hours?
Hour, maybe?
An hour?
Maybe.
And you stated that you previously told Ms. James she was not allowed in your home, is that?
That is correct.
Okay. So it's fair to say that you weren't happy when she arrived, you weren't happy when she was in your home, is that correct?
I was observant, so just not being happy is not a truly accurate description.
Were you happy to see her at your home?
Absolutely not.
Okay, so you were not happy, correct?
That doesn't make me not happy. I was in the middle. I had no anger or nothing.
Okay. Now, according to your testimony, at some point, Ms. James, she threw a plate in the air, is that correct?
Yes, that's correct.
Okay, she was upset with something that you said, is that fair to say?
That's correct.
And she reacted to a threat you made of her and her child, isn't that correct?
There was no threat, no.
Okay, what exactly did you say to her?
I attempted to tell her and her mama what that child had done. Their response was, he didn't do it.
Okay, and then you stated that she threw a plate in the air and you started to say something to you, is that correct?
Yes, that's correct.
Okay, what exactly did she say?
Many things.
You stated that she was acting like a guy, is that correct? What do you mean by that?
When did you hear me say that?
Sorry?
When did I say that?
You testified to that. You said she was making statements that were similar to what a guy would.
Oh, there it is, yes.
What do you mean by that?
Threatening what she can do to me, what she will do to me.
How is that similar to what a guy would say?
In a threatening situation, often there's a lot of verbal back and forth.
I'm not understanding how it's relevant to what she said and how that's similar to what a guy would say.
I don't understand what relevance you're missing. She jumped up out of the table like, this is what I will do and whatever. And she said a few things, I said a couple things, and she took off up the hill.
And how is her behavior similar to what a guy would say? I'm still not getting an answer from you.
It's threatening in the sense of a guy.
How is that different from what a female would versus what a guy would do?
I assume it may be the same, but from my viewpoint, that's what I saw. Because a female would not sensibly throw threatening postures, words, and all of that at a guy.
Okay. So you it's fair to say that you have an issue with her demeanor and how she is. Is that correct?
That is not correct. I have been on mute for years when certain people come around. The way that they choose to live, I do not say a word about it to them. So no, I have no, to your question, no.
But in your opinion, she was behaving as a male. She was behaving like a male more so than a female.
Your Honor, we're asked and answered. He's told Mr. Davis what he means. I think that continuing to berate this issue is one, asked and answered, and two, irrelevant.
Thank you.
Now, you indicated at some point there was a firearm, is that correct?
Yes,
And she was approximately 12 feet away from you, is that correct?
when I saw her, yes,
Okay. There was an island separating the two of you, is that correct?
yes,
Okay. Is it fair to say that the firearm was pointed in the air?
no. It was pointing at me.
And you turned around and saw this firearm? Is that correct?
Yes, because she came in with big talk. That's what made me turn around. So a lot of talk, I turn around, what's going on, and I see a pistol going at and pointing at me.
So at some point, was your wife who was to take the firearm
Yes,
from Ms. James, is that correct?
yes.
All right, I know.
Thank you. Any redirect?
No.
Mr. Anderson, thank you for your testimony. You may step down, sir. He, Ms. Bailey?
Unless he wishes to speak with you, Your Honor, I have no further need for Mr. Anderson this morning.
I don't have additional
Thank-
questions. or anything for me. I'm fine with it.
Thank you. Ms. Dennis, Mr. Anderson may leave.
If he wants to wait
Okay,
outside, I'll speak.
you
with
have to wait. We have a couple other things scheduled, Mr. Anderson. Thank you.
I'll be right back.
Your next witness, ma'am.
Your Honor, the people have no further witnesses at this time.
Mr. Davis, any witness?
No witnesses, Judge.
Argument, ma'am.
Your Honor, at this time, the people move for bind over on counts 2 and 3. I don't believe that the people have been able to establish the concealed carry. The complaining witness in this matter, Renell Anderson, indicated that he was in the kitchen fixing a plate or something during this party. And when he turned around, the defendant was inside of his kitchen with a gun pointed at him, threatening to kill him and threatening, I'm going to kill you at the very least, waving it up and down, pointed at the side directly at him from 12 feet away, Your Honor. It is reasonable that a person could believe that they were in danger of an imminent battery with a gun being pointed at them from 12 feet away. I don't believe I've elicited any testimony that would indicate that she had it concealed on her person prior to Mr. Anderson seeing it. He indicated that it was already out and he didn't observe her pull it out. So that is why I'm not asking for the bind over on count 1.
Thank you. Mr. Davis.
Yes, Judge, that's the argument I was going to make. I believe that there's probable cause for count 1, and then count 2 and 3 are going to be pushed aside.
Anything else, Mr. Davis?
No, Judge.
Anything else, Ms. Bailey?
Nothing further from the people.
Based on the testimony provided both by Officer King, Mr. Anderson, and the concessions made by defense counsel regarding counts 2 and 3, court will find that the people have met their probable cause burden in this matter, will bind Ms. James over on counts 2 and 3. Count 2 being the felonious assault and count 3 being the felony firearm. The next appearance in this matter will be in circuit court on October 19, 2022 at 9 a.m. for an arraignment on the information. Ms. James' bond is currently 5,000, 10% with the no contact. That bond will continue unless there's anything else from the people.
Nothing further from the people.
Anything else from the defense? Thank you. Ms. James, your next appearance date is October the 19th, 2022 at 9 a.m. That concludes this matter with the court. Good luck to you, ma'am. Have a good afternoon. Ms. Bailey, in addition to preparing for the next case and needing to speak to Mr. Anderson, this court will be in recess. Let's say 15 minutes, 20 minutes. When you're ready, if you let Officer Garcia know, we'll come back out.
Yes, Your Honor.
Thank you.
then you will be sitting right there. Yeah, we are over right next door. You were over there. Was built back in 730. This was just, we just got in here just over a year ago. It was built before COVID. But when COVID hit, it sat for about 2 years. So we've been here May of 2021. He's nice. Please rise. Now, session. Lisa and Mark.
Did you actually look at the sign? You may be seated. Like Brooks and just make up a name. What did you say? This is court that is actually in session. This is 220434 FY, State of Michigan versus Constance Selena Davis. May I have your appearances, please?
Good morning, or afternoon, Your Honor. Bryn Bailey on behalf of the people, P84009. Good afternoon, Your Honor. Name and defendant service, Dr. Shaka Kirkland on behalf of Ms. Davis, P84015.
Your name, please, ma'am.
Constance Selena Davis.
Thank you. Today is the day and time set for the preliminary examination in this matter. There is count 1, fraudulently obtaining controlled substances. Count 2 is the misdemeanor obtaining by false prescription controlled substances. Are the people ready to proceed this afternoon?
The people are prepared to proceed, Your Honor. However, my conversations with Ms. Kirkland have indicated that her client wishes to waive the preliminary examination.
Ms. Kirkland?
That's right.
Ms. Davis, would you stand and raise your right hand for me, please? Do you swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
You can put your hand down. You've had the opportunity to discuss this case with Ms. Kirkland, including all possible penalties that you face.
Yes, ma'am.
You understand that you have a right to have a preliminary examination where the prosecution would have to show that both a crime had been committed and probable cause exists to believe that you were involved in the commission of that crime.
Yes, ma'am.
And knowing that you wish to waive your right to the exam.
Yes, ma'am.
You haven't been threatened in any way, promised anything to get you to execute the waiver.
No, ma'am.
That being the case, the court has sent the file down to both you and Ms. Kirkland to sign that you are agreeing to waive the exam. Is there any objection from the prosecution?
No, Your Honor.
Jamie, there's actually a place for Ms. Bailey to sign. Is it the old form or the new form?
Both signed down there, is that correct?
There, right below their signatures is one for Ms. Bailey. That's the newer form. Thank you. Ms. Davis, once the prosecutor signs the waiver, it will come back up to me. I will sign it. Based on all three of you signing the request for waiver of the examination, the next step in these proceedings is that you will be bound over as previously charged. I'm stumbling this afternoon. You'll be bound over on all counts as previously charged. Your next appearance date will be at the Frank Murphy Hall of Justice. That will be on October the 19th. October the 19th, 2022 at 9 a.m. for an arraignment on the information. Your previously entered bond, which is $10,000 personal, will be continued Is there anything else on behalf of the people?
No, Your Honor.
Anything else, Ms. Kirkland?
No, Your Honor.
Ms. Davis, that concludes the proceedings this afternoon. You have a wonderful afternoon and good luck to you.
Thank you.
Thank you, sir.
No, that's okay. I'll read. No, nothing. I'm serious. I'll ask you when we step out.
All rise. We report this court now session. Judge Martin presides.
You may be seated. This is 220556FY, State of Michigan versus Pat Robert Thomas. May I have your appearances, please?
Good afternoon, Your Honor. Sonam Obsidian on behalf of the people, P83923. Good afternoon, Your Honor. Neighborhood Defender Service, Beth Shaw Kirkland on behalf of Mr. Thomas, P84015.
State your name for me, please.
Pat Thomas.
Thank you. Today is the day and time set for the in-person preliminary examination matter. There is count 1, domestic violence, third offense. Count 2, police officer assaulting, resisting, obstructing. Are the people ready to proceed?
Yes, Your Honor, we are ready to proceed.
Defense ready to proceed.
During this time, Mr. Thomas will actually
Mr. Thomas, would you rise and raise your right hand for me, please, sir? Do you swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth? You put your hand down. Thank you, sir. You had the opportunity to discuss this case with Ms. Kirkland?
Yes.
You understand that you have an absolute right to have preliminary examination in this matter where the people would have to show that both a crime had been committed and a probable cause exists to believe that you were involved in the commission of that crime. And after discussing the matter with Ms. Kirkland, you wish to waive your right to have that examination? And you do so freely and voluntarily?
Yes.
You haven't been threatened in any way, promised anything? Any objection, Ms. Moisezian?
No, Your Honor, thank you.
Mr. Thomas, there's a form that will be signed. The prosecution has no objection to the waiver she's signing. Ms. Kirkland will sign, you will sign. The file will come back up to me to sign that waiver as well. After the waiver is signed, the next step in the proceedings. The next step in the proceedings will be an arraignment on the information, which will be on October 19, 2022 at 9 a.m. at the Frank Murphy Hall of Justice. Is there anything else from the prosecutor?
No, Your Honor, that day was October 19th, correct?
Yes, ma'am.
Okay, thank you.
Anything else from the defense?
Nothing from the defense, Your Honor.
Mr. Thomas, your previously entered bond with any conditions continues. That concludes the matter before the court this afternoon. Good luck to you, sir.
Thank you.
You're welcome.
Let's work on the next one.
The one-
Thank you.
Is the 1 o'clock's gonna start on time? Close to on time?
102 now.
Oh, thank you, Officer Garcia. Mr. Upshaw,
Yes.
how are you this afternoon?
Oh, I'm doing pretty well.
I'm concerned that you have a 1 p. What happened? Mr. Upshaw?
Okay. I'm sorry.
I'm a little concerned that you have a 1 p.m. live exam and you are not here.
You know I have a good excuse for that, Your Honor.
It better be good. Let's hear it. Oh, wait a minute. The
right.
prosecutor's not here. Hold on 1 second. Somebody come here. Somebody come here. Come here. You come here. Yes, please. I just need somebody to get a prosecutor for me. The defense counsel is on for the 1 p.m. exam. She can either log back on or somebody can physically come in the room for me, please. Before I start talking to Mr. Upshaw. Yes. If the attorney's here and I'm trying to get the attorney, one of them to get somebody and they just stand. She was on and then she disappeared, but Mr. Upshaw is here on Zoom. I think Mr. Upshaw has an excuse.
Okay, so we need a prosecutor.
A prosecutor, yes, thank you. Thank you. So all 3 of those attorneys see me waving and nobody will come in here. No, I need you all. This is 220407 FY. This is State of Michigan versus James Thomas Kemble. Your appearances, please.
Good afternoon, Your Honor. Bryn Bailey on behalf of the people, P 84009.
And Your Honor, Randall Upshaw, P number 43574 on behalf of Mr. Kimball.
Ms. Bailey, I've already indicated to Mr. Upshaw that the court is concerned that this is a live examination and he is on Zoom. Mr. Upshaw, you were starting to explain what the situation is.
Yes, Your Honor, I called my staff called the court. I received a call 7 o'clock this morning that Mr. Kimball was in the Henry Ford Wyandotte Hospital. He just called again. So I started calling the court and had my staff call and leave messages that he's in the hospital.
And sir, your request is?
It's in this, we need an adjournment. I cannot go forward without him.
Thank you.
Your Honor, given that the defendant is in the hospital, I do believe that that constitutes as good cause for an adjournment. I think if he could provide some proof for the next date, I think that would also be helpful. But Your Honor, I'm not going to object to an adjournment. I think there's good cause.
The court finds good cause to adjourn the exam. Mr. Upshaw, this court's next available day is November the 23rd. Hi. I need an adjourn date for an exam, November 23rd. I'm sorry, I thought you were listening back there. Don't rush. I was gonna find good cause. I was just waiting for Mr. Upshaw to make his ask. I just need the record to be complete, that's all. And he's sitting there with no jacket on. The first time I saw Mr. Upshaw, don't jump up, sir, I'm just giving you a hard time. The first time I met Mr. Upshaw, I had been out of law school for probably a year. He was driving over to Kalamazoo every day for a trial, a 3-defendant trial. And he would be on time more days than not, which was shocking to me considering where he was driving from.
Yeah, Your Honor knows, there's been a couple of close calls with me being on time.
But we would laugh because he was coming from South Hills. I was in Kalamazoo, Judge Foley's courtroom. My first job out of law school.
This is my second job out of law school.
It is at 2 o'clock, Judge.
I was just filling the air until Mary Ann gave us that time. The adjourned live exam date will be November 23rd, 2022 at 2 p.m. Mr. Upshaw will provide documentation to the prosecution to support the defendant being unavailable today. Is that satisfactory, ma'am?
Yes, Your Honor.
Anything else from the people?
No, Your Honor, thank you.
Anything else, Mr. Upshaw?
Nope, and thank you very much, Your Honor.
Good to see you, sir. Have a good afternoon.
It's always a pleasure, Your Honor.
Good to see you, ma'am. Yes, thank you. And Crova, just like that, we're back on track. Our next case is scheduled till 1:30. Whenever they're ready, we're ready. Thanks.
Ma'am, can you hear me?
Yes,
Hi, good afternoon. What case are you here for?
I am here for Erica Elaine Lawrence.
It's a live exam.
Okay, so you don't need me here?
Well, I don't know, how are you associated with the case?
She pointed a gun at me?
Oh, so you're the victim?
Yes.
Oh, it's a live exam. Are you out of state or did you talk to the prosecutor?
I have been calling all morning. Somebody called me a month ago and told me I needed to be in court. I have never received anything in the mail. I called the court 3 times this morning and they said that it was a Zoom and I needed to get on the Zoom call.
Oh, okay. Do you live here?
Yeah, I live right down the road.
I think if you could get here, I would get here.
But I might not be there in 10 minutes.
What is your phone number? You know what I'll do? I'll have the prosecutor call you.
734 732 7974.
732-7974.
Yes.
Okay. All right, I'm gonna go give her your phone number and have her call you right now, okay?
Okay, thank
All right,
you.
thanks.
Mm-hmm.
Yes. She said she hasn't spoken to anybody. All right.
Why are you screaming? You scare people. You may be seated. And there's no prosecutor. Miss Dennis is back there laughing. It has been a day. We don't do all that screaming in courtroom one. So I'll do my little lecture about adjournments. And we'll use that date. And then our next date will be December 28th. Our next exam date is December 28th. I am gonna start scheduling cases every 15 minutes for exam, and whatever happens, happens. I would never do that. I'm not gonna force anybody to accelerate their case like that. It is what it is. Tell people I'm here Monday through Friday, 8 to 4. I don't care when we do it. One of the students yesterday, the question was, do we have a preference, live or Zoom? Like, I'm here. I'm in the courtroom, whether they're standing here or I'm looking there, it's 6 of one, half dozen of the other to me. This is 220421FY. This is State of Michigan versus Erica Elaine Lawrence. May I have your appearance, please?
Good afternoon, Your Honor. Bryn Bailey on behalf of the people, P84009. Good afternoon, Your Honor. Neighborhood Defender Service, Detroit by Nancy Richards, P68850. Hearing on behalf of Ms. Lawrence, who stands to my right. I'm Erica Lawrence.
Thank you so much. Today was the day and time, is the day and time set for the preliminary examination. In this matter, there is count 1, felonious assault, count 2, weapons felony firearm, count 3, carrying concealed weapon. Prior to this case being called, the prosecution and the defense attorney asked for a sidebar. There has been, Ms. Bailey, I'll let you make your own record.
Yes, Your Honor. There was an issue with my complaining witness who thought she was supposed to appear today via Zoom. I corrected that and as did your staff when she was on her way over. Additionally, it was brought to my attention maybe a week ago? Yeah. A week ago that there was some issues with the discovery, namely a photo lineup, issues with audio on a video, and then an in-car video that hadn't been tendered. I made the request over to the officer in charge and hadn't received anything back yet today. It is my understanding that Ms. Richards believes and not having seen them, Your Honor, I will leave it to her, but I think that they are necessary for preliminary examination. As such, we are jointly asking for a good cause adjournment.
In particular, the lineup is important to have her.
Thank you, Ms. Richards and Ms. Bailey. Both of you have previously heard this court indicate that that exams would not be adjourned if the defense was not satisfied with the discovery when an exam date was requested when discovery was outstanding. And as much as Ms. Bailey has indicated on the record that part of the discovery being incomplete in this case is chargeable to the prosecution, the court will find good cause and adjourn this exam. Our next available exam date is November 23rd, 2022 at 2:30 p.m. here live in courtroom number 1. Anything else on behalf of the people?
Nothing from the people.
Anything else on behalf of the defendant?
No, Your Honor. Thank you.
Thank you. Ms. Lawrence, I'll see you here on November 23rd at 2:30, ma'am. Have a good afternoon. Thank you. Up, down, up, and down. Yes, for you. Thank you. Oh, it didn't reach the slide.
This is it.
Again? That would be bad. Your bailiff is in here. What? So the bailiff is in here.
Maybe we have to go
All
get
right. They're just fooling around outside.
I can fill in for them.
I bet you could.
I can read the name too.
You do better than Jamie, that's for sure.
Everyone's excuse for coming up here. Carol. Why? Do I personally own a gun? That's what Officer Brooks and Detective Long report. We've had this conversation. I started shooting a gun when I was single digit age, and then I just didn't for a long time. And now it's been another 10 years. No reason why I haven't shot a gun. Where do I go in my day that I would shoot a gun? Here, where they're everywhere, except for in the courtroom,
Judge?
obviously.
Sorry, can I ask you a question unrelated to this case?
Can you ask me?
May I ask?
Yes, ma'am.
So is there, the tether unit officers from, Wayne County Sheriff emailed me asking if there is a good email address for you, to send a report for this morning's case. Is that okay for me to share your address or should it go through the
I
court?
should go through Mary Ann.
Okay.
Nobody can send me anything directly. Are you crazy? I've been emailing the judge, absolutely.
Just search warrants, right?
Ms. Richards and Mr. Martin wouldn't have any problem at all with your communicating directly with the judge. I can't imagine that would be a problem. We've had this ongoing conversation about how secure this building is, and understood.
What's your name? Sarah Martin, Sona. You guys in 34th or just? Okay.
On the unrelated matter,
Yeah, you can call me Sona.
no. Ma'am, on the unrelated matter, is that report going to generate an emergency motion from you?
So I guess I don't know because would it wouldn't we have a hearing automatically? If a,
Depends on what the nature of the report is. And that's why the court had a specific question about, was it A going to B or B going to A, which is something we'll take up
yeah.
as the time is appropriate. These are 220495FY and 220628FY. These are both State of Michigan versus Jerome Henry Curtis. May I have your appearances, please?
Good afternoon, Your Honor. Son of CC on behalf of the people, P83923. Good afternoon, Your Honor. We were defenders of Detroit by Nancy Richards, P68850, appearing on behalf of Mr. Curtis, who is the
State your name for me, please, sir. Thank you. There are two matters this afternoon. There is the 220495 case, which is scheduled for an in-person preliminary examination. But in reviewing the file, Ms. Moisezian, I made Ms. Richards aware of this. There is a warrant outstanding for Mr. Curtis on 220628 FY, State of Michigan versus Curtis, with an offense date of July the 26th, 2022. The court did provide Ms. Richards with a copy of the bond recommendation, the warrant, and the complaint in this matter. And I know that the practice is not typically to take up such things, but inasmuch as there was a warrant outstanding, Ms. Richards, is your office prepared to have Mr. Curtis arraigned on this, or should we put it over till next week and do an arraignment PCC next Wednesday?
Your Honor, either way would be fine with me. I'm prepared to arrange now. I know that we would still need a PCC though, so if the court prefers to just do it all PCC, that's fine.
Court has no preference. However you wish to proceed.
We can go forward that day.
For purposes of arraignment in the 220628 FY case, the court will recall the outstanding warrant, and for purposes of arraignment, Ms. Richards.
We would waive the formal reading, Your Honor.
There was a recommendation from Van Buren Township Department of Public Safety that Mr. Curtis's bond be set at 20,000, 10% in this matter, indicating that he has some outstanding felony and misdemeanor matters. Ms. Richards, what say you as to bond?
Your Honor, I would ask the court to consider a personal bond. Mr. Curtis is in custody on this other matter. He cannot make that bond. He is homeless at this time as well, has no source of income that I'm aware of, so I would ask the court to consider it.
Court will set Mr. Curtis's bond in this matter at 10,000 personal. Mr. Curtis, Ms. Richards represents you in this matter. I'm not sure, Ms. Richards, if you would continue in the exam matter. I'm not sure, would you continue to represent him in this receiving and concealing matter?
Yes, Your Honor, I would be.
Thank you.
It will be out of this court, correct?
Correct. And the exam, I'm sorry, the PCC date, 1 week, 2 weeks, 3 weeks, do you have a preference, Ms. Richards?
1 week would be fine.
(10:15) 10:50. PCC will be next Wednesday, October 12, 2022 at 10:50 a.m. back in courtroom number 1. For the case at hand, I'm sorry, was there anything else in that first matter, Ms. Richards?
No, Your Honor.
Thank you. In 220495 FY, there is count 1, home invasion, first degree. There is a count 2, domestic violence misdemeanor matter that will travel along. Are the people prepared to proceed?
Yes, we are, Your Honor.
Defense ready to proceed?
Yes, Your Honor.
Any preliminary matters, ma'am?
No, Judge.
Any preliminary matters, Ms. Richards?
I'd ask for mutual order of sequestration.
Absolutely. If there is anyone currently in the courtroom who is likely to give testimony in this matter, at any point, you should remove yourself from the courtroom. Anybody viewing these matters on any streaming or recording platform who might potentially give testimony in this matter at any point should cease to review this proceeding at this time. Any other preliminary matters, Ms. Richards?
No, Your Honor. Thank you.
Your first witness, ma'am.
Thank you, Judge. The people call the complainant Rachel Ressler.
Ms. Wrestler? Good afternoon. Come all the way up to this podium for me, please. State your first and last name and then spell them for the record.
Rachel Ressler, Rachel, last name Ressler.
Raise your right hand for me. Do you swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you, ma'am. Please come up here, have a seat in this black chair that is closest to me. My secretary is taking down your testimony. If for some reason she's unable to hear you, I'll ask you to either raise your voice or pull the microphone closer, okay? Thank you. Your witness, ma'am.
Thank you. Can you please state your name again for the record?
Rachel Ressler.
Thank you, Rachel. And do you know an individual named Jerome Curtis?
Yes.
How do you know him?
He was my ex.
When you say ex, as in,
That my ex-boyfriend, we were together for 17 years.
did you guys have any children in common?
Yes, we have one child.
You said ex-boyfriend, so did that relationship end at some point?
Yes.
When did that relationship end?
Don't have an exact time, but we had been rocky over almost the last year.
And were you guys living together as well?
Yes.
Where were you living together? Let's start there first.
At 149 Ponderosa Trail South in Belleville, Michigan.
And is that in Wayne County?
Yes.
And I believe that also may fall under Van Buren Township.
Yes.
How long were you living at that residence together for?
Together, we lived there for about 17 years.
So the entirety of the time you lived together? Understood, okay.
Ms. Russell, I need you to keep your voice up for me, please. Thank you.
Yes, sorry, everything is being recorded, so if you can just speak up and make sure that you answer verbally instead of nodding or shaking your head, just so everything is picked up. Thank you.
Okay.
At some point, when you said that your relationship ended, did Jerome Curtis remain at that residence with you?
Yes.
And up until when did he remain there?
Memorial Day on 5:30, there was an incident where I had called Washtenaw County Police Department, and after that point, he hadn't been there, but before 5:30, he had left and came back. And honestly, I don't have exact dates and times. I was trying to end the problem, and he had been coming and going.
Okay, and that's okay. So, but you know, as of at least 5:30, when you say 5:30, do you mean of this year?
Memorial Day, yes.
Okay.
That was the day that I called for the strangulation in my car with Washtenaw County.
And so at that point, after 5:30, after May 30th or Memorial Day of this year, had Mr. Curtis resided or stayed at that residence between end of May and July?
No.
And did he have a key to that residence?
No.
And when you say that he had, so to speak, moved out, did he gather his possessions?
He had given most of his possessions to his son prior. He had taken clothes, and I was told to throw away any remaining possessions.
Judge, it's not to be introduced to proof of the matter asserted, it's just to show the response on the listener.
Ms. Richards. The court is not taking it for the truth of the matter asserted. Ms. Ressler, going forward, when you hear one of the attorneys say objection or some effort to interrupt you, stop talking for a moment. I'll make a ruling and then we'll resume your questioning, okay? Thank you.
So I'm sorry, going back to his possessions, can you state what you saw or didn't see in regards to his possessions? Let me rephrase that question. You mentioned that his possessions were given to his son and other possessions were taken out. Anything else in regards to his possessions, whether that they remained or were not there?
The little possessions that remained, I was told by Jerome to throw away. He did not want anything else.
Okay. Do you recall an incident that occurred on July 5th that brings you to court today?
Yes.
Okay, so we're gonna talk about that, and I know there's a lot to unfold, so we're gonna take it one step at a time. Can you describe, did you have an encounter with Mr. Curtis that evening?
Yes.
Do you recall what time you saw him initially?
When I got home from work,
Which was when?
roughly around 5 p.m., maybe a little later.
Okay, and so what happened during your initial encounter with Mr. Curtis?
Initially, he had asked to come in and use the bathroom, and I agreed.
I'm sorry, can I ask, when you got home from work, was he already there or did he show up
Yes,
afterwards?
He was already at my home when I got home from work. He was outside, sleeping on my porch.
Okay, and so, sorry, continue.
He was sleeping on my porch, and me and my daughter went in the home, and he woke up while we were in the house. He knocked on the door and asked to use the bathroom and to get a cup of coffee, and I let him in to use the bathroom.
Okay. And you said your daughter was there as well?
Yes,
And how old is the daughter that you guys share?
she is 8 years old, and she's special needs.
And so what happened after he used the restroom?
He sat down after making a cup of coffee, and I became uncomfortable. That's why I called the police, because I asked him to go back out and he didn't.
Okay. So you called the police because you asked him to go and he did not leave.
Yes.
And then when you called the police, what happened?
They came and they took him outside. Honestly, before I called and I asked him to leave, he did raise his voice to me. That's why I became uncomfortable. I'm sorry, going back to this day, I've been trying not to think about this day, to be honest with you.
You
But
can take your time, that's okay.
I did become uncomfortable because he raised his voice. I did not feel comfortable being alone in the house with him, and I asked him to leave. I called the police, and he remained in the home until the officer got there, and the officer took him outside and separated us and talked to him outside.
Okay. And at that point, did Mr. Curtis return to the residence or what did you see happen with him?
The officer first came back in and told me that
Without saying anything that the officer told you, just what you observed.
he left and
When you say he, who?
returned. Well, that's what he wasn't outside.
Mhm.
And then within, I don't know, 10 to 15 minutes, I heard a knock on the door.
Okay,
It was Jerome.
Okay, so when you say he left, who are you referring to as the he?
Jerome,
Okay. And at that point, had the officer also left?
yes.
Okay, and once both Jerome or Mr. Curtis and the officer had left, were you alone in the home
With my
with your
daughter.
daughter? Okay. And what was your understanding at that point when the officer had left as well? Did you believe Mr. Curtis was present or that he had left?
I believe that he had walked when the cop told him to leave, or he would take him in on the warrants that he had, and I believe he left.
Okay. And then, I'm sorry, you mentioned that a short time after you said he came back. Who came back?
Jerome.
Okay, and do you recall how long after he came back?
It was as soon as the cops were there. As soon as the cops were gone, he was right back at the door.
Okay, and what was he doing when he came back?
He wanted me to give him a ride. He was aggravated that I called the police on him in the first place. He was wanting a bike inner tube to fix his bike and tools. So I did put the toolbox outside. He demanded he needed tools to fix his bike. I did not let him back in. He was aggravated and yelling at me and said since I wasn't going to help him, he demanded me roll him some cigarettes. I've been scared of him, so I did. And when I rolled cigarettes and I put some in a little bag, I went to crack my front door and slide them through. So that way he has everything he wants. Just go, please. I cannot give you a ride. And that's when he forced the door open past me.
Okay, so when you were having that conversation with Mr. Curtis, prior to you, like you said, cracking the door open, where was that conversation or how was that conversation being had?
Through cracking the door and yelling. You can literally hear someone screaming right through the door.
Okay, so what part of the house was he at?
At the front door. He was outside my front door, screaming and demanding, saying mean things. I need my stuff since you're not gonna give me a ride. And then demanded cigarettes. And I slid cigarettes through. I just cracked the door a little bit and slid through, but he's stronger than that. He pushed the door open on me.
Yeah, so when you said that he forced himself into the home, can you describe exactly how he did that?
I was on the inside. I opened the door, cracked it, went to slide the cigarettes through the crack in the door, and he just pushed his way in, and I can't remember if he got a foot or a leg, but he got a part of his body through that door to where I could not push it closed. And I went back. I started backing up. He came into the living room about 4 feet from the front door. And at this point, I had dialed 911 and wasn't speaking to them yet, but my phone had 911 on it and I was holding it out in front of me. And as soon as he realized that I had called 911 a second time, he got really mad at me and he came at me and just started swinging fists.
Okay, so prior to you cracking the door open, did you invite him in, like during the second time when he came back? At any point,
No.
did you allow him to come back in?
No, I did not invite him or ask him to come in. I asked him to please leave.
So you did give him statements to leave your residence?
Yes, I told him I cannot give you a ride anywhere. I told you I'm not comfortable being alone with you in a car. And he was aggravated that I wasn't giving him his way.
Okay. And when you said he came in and was swinging with his fist, did his fist make contact with your body?
Yes.
And where did it make contact?
The side of my head. He bruised my right breast really bad. He was hitting me in the rib cage and the torso. I went backwards over the kitchen island counter and tried to get away. That at this point I had my phone and I started screaming into it to 911 saying come back, screaming my address, screaming my name, saying he's attacking me. And I tried to get away from him and went back to the bathroom, but he followed me back there and swung on my torso a couple more times in the bathroom.
And at this time, was your daughter still present in the home?
Yes,
Where was she?
she was in the bedroom.
And then when you were in the bathroom and he followed you into the bathroom, what happened afterwards?
I found myself sitting on my bathroom sink, cowering with my hands above my head in a protective position. And he left. He immediately ran out. And initially, after what just happened to me, I went into my bedroom where my daughter was and closed the door and was talking to 911 dispatch. But during that time, Jerome had fled the house because he knew the police were coming. He had fled the house. So I got lucky. He stopped hitting me and he just left.
How did you feel when the assault was happening? What was going through your mind?
Scared. I was very scared.
Was he saying anything to you when he was assaulting you?
I mean, he said a lot of horrible things that day. I was a fucking bitch that won't help him. All he wanted was a ride. I didn't have to do this. I could have just gave him a ride. But he didn't respect me not being comfortable alone with him in a car after he strangled me on Memorial Day. I was scared, and when he was swinging on me, I don't believe he was speaking. If he was, I couldn't hear it.
And were you saying anything to him when that was happening?
Yeah, please stop. Ow. Why are you doing this?
And you mentioned that he made contact with various parts of your body. Did you sustain any injuries from that?
Yeah, bruising. I didn't go to the doctor, but the officer did take pictures of everything minus my right breast. I have personal pictures of bruising that remained there. And days later, I kept finding scratches and stuff and bruises that were popping up, scratches around my neck, in ear area.
Do you know how you got the scratches?
From Jerome swinging on me. His fingernails he just was swinging in fury. It wasn't calculated. I believe his nails caught me.
Okay. And so we've been talking about an individual named Jerome Curtis. Do you see him in the courtroom today?
Yes, I do.
Can you please identify where he is sitting or what piece of clothing he's wearing?
He's wearing a green shirt and he's behind you to the left.
Judge, and that would be to my right. Yeah, just for the
Your
record.
right to my left.
Yes, thank you. May the record reflect that the witness has identified the defendant as Jerome Curtis.
Yes, ma'am.
Thank you. One moment, please. I have no further questions. Thank you.
Thank you. Ms. Richards.
Good afternoon, Ms. Ressler. Just have a few questions for you. If at any time you don't understand something, you stop me and let me know, okay? So you indicated that you and Mr. Curtis were in a relationship for about 17 years?
Yes.
And during that time, the two of you lived together in the home where you say that this happened?
Yes.
Okay. And was there a lease or a mortgage to the home?
I own the home. He moved in with me back in 2004.
Okay.
And he's been living with me. I've been been taking care of him for the last few years that he's been without work. I've been the sole provider for me, my daughter, and for him to the point that it broke me.
So 2004, he moves in. Is that correct? Okay, and remained there until, you said May 30th?
I mean,
Approximately?
Roughly back 10 years ago, we had a couple little split ups that he might have left, but going back over 10 years, for the bulk of this time, yes, he lived there with me.
Okay, so there were other times where you would split up and he would move out, but then you'd get back together and move back.
It happened twice over 10 years ago.
Okay, so this time when he moved out, he left voluntarily, correct?
Yes.
And he left because he was trying to get into drug treatment.
Not to my knowledge.
Okay. At the time when he left, had you had discussions about taking a break in your relationship?
Can you reword it? The time that he left, what?
When he left your home and stopped living there, had you had discussions with him about taking a break in the relationship?
I was trying to get away from him. I didn't want to have any discussions.
Okay. But he left on his own, you said?
Yes.
Okay. And so there hadn't been a discussion about
He didn't
taking a
leave
break?
peacefully.
Okay. So had you broken up or were you taking a break?
I've said I'm done, and if you don't understand what I mean by that, I don't know what else to say. We didn't really ever have a serious sit down. We didn't even enter a relationship with a serious sit down conversation.
Okay. So to you, there wasn't any specific language that said we're breaking up, correct?
All the times that I said I'm done, I can't do this anymore, you're destroying me.
Okay.
Was seriously, he needed drug treatment, yes, and we tried, I took him to rehab. I
Okay.
called every day and I got him a bed and I dropped him off and he didn't even stay 24 hours, he walked back home.
Okay. And you said that prior to the date that he left the home for good, that he had been coming and going. So on and off at your home. Is that fair to say?
He left and he popped back up and then just stayed, he wouldn't leave.
Okay.
He said he wasn't going to leave while anyone else was there or anything like that.
Did he ever have a key to the residence?
Yeah, he's had a key.
All right. So on this day, July 5th, you said that he knocked on the door and asked to use your bathroom and for a cup of coffee.
Yeah, after sleeping on my porch.
Okay. And so you let him in, let him use the bathroom. He had a cup of coffee, was sitting in the living room. And then at some point you said he raised his voice and you felt scared. Is that correct?
When I agreed to let him in to use the bathroom, yes, he did come in. I didn't want him hanging out in the home with me, and that's why I got scared, because he sat down and just acted like, oh, well, everything's back at it.
Okay. So how long had he been in the home before you started to feel uncomfortable?
Oh, man, quick. I was uncomfortable letting him use the bathroom.
Okay. How long had he been in the home before you decided to call the police?
10 minutes.
Okay. So you indicated that he left when the police came and talked with him, and then he returned almost immediately.
Oh, yeah.
All right. And when he returned, he was asking for tools.
Yes, he was asking for, he wanted stuff to fix his bike. He
Okay.
wanted me to give him a ride and I was refusing.
Okay. And the tools that were there were his tools, correct?
Yeah.
Okay. And the bicycle inner tube, that was his bicycle inner tube, correct?
No, I bought it. I
Okay.
bought everything. It was technically, I mean, I bought it for him. I guess it was his, but in possession,
Okay.
I bought it.
So when he asked for the tools and the bicycle parts, you gave those to him?
Yeah.
And how did you give it to him? Did you go outside with him? Did you open the door and hand it to him? How did you give him the tools and the bicycle parts?
You know, the tools might actually have been there. I can't remember, I can't recall if I gave him the tools the first time or the second time, but I do know that the officer's body cam is gonna distinctively see all the tools scattered on my front porch, because I
Okay,
slid the toolbox outside and I can't
The question
remember
I'm asking,
exactly.
do you remember how you actually physically handed him the tools?
No.
Okay.
I don't.
All right. At any point were you outside interacting with him while he's using the tools?
No.
Okay. And so he takes the tools, the bicycle parts, he's, at that point, was he fixing his bike?
He didn't know. He wanted me to give him a ride to his bike. He didn't even have a bike there.
Okay. And then he asked you to roll him cigarettes.
He demanded I roll him cigarettes since I refused to help him.
Okay, and you did roll cigarettes, correct?
Yes.
So from the point that he's interacting with you the second time, to the time when he pushes the door, about how long time passed there?
Minutes.
10 minutes, 20 minutes?
Less.
Okay,
5.
okay,
They all happen very fast.
all right,
I can roll a couple cigarettes really fast.
okay. So it was 2 cigarettes that you rolled?
More like 5.
Okay,
5 or 6, and throw them in a little sandwich bag and went to slide them through the door.
okay. But you said that you did not invite him in.
No.
When the police officers first spoke with you that day, the first time that you called the police, it's true that they told you that they weren't going to keep coming back here to remove him if you keep inviting him in.
Yes.
Okay. So how long after the police left the first time did they come back?
Probably 15 minutes, maybe less. I'm not sure.
So it was a very
911
quick
calls
time.
would prove it.
I'm sorry, 911 calls.
The 911 calls would reveal that exact timeline. I mean, those are all recorded, and I called 911 twice. And there's real live time, like while I was being hit and attacked, my phone was in my hand being recorded. Like through the dispatch, they were on the phone the whole time.
Okay. So your perception was it was about 15 minutes after the police left that they were back at your home.
Maybe even less. I mean, as soon as the cops disappeared, he was right back at my door, which I knew would end up happening. And then I called the police, and then I got hit. I went into my bedroom and hid. And the next thing I know, I hear an officer that's in my living room.
Okay. And this time when you called the police, you did tell them that he had forced his way in and you did not invite him in, correct?
Yes.
Are there video cameras inside your home?
Yes.
And were those video cameras working that day?
They were not recording anything. They were in the bedroom. It's nothing where he attacked me. It's not on camera.
There's no video cameras in the living room?
No.
I have nothing further.
Thank you. Any redirect, ma'am?
No, Judge, thank you.
Thank you. Ms. Wrestler, thank you for your testimony. You may step down.
Judge, the people just have one more witness. We call Officer. What's his last name again?
Mowbray.
Yeah, thank you.
Good afternoon, sir. State your first and last name and then spell them for the record, please.
Curtis Mowbray, Kurtis, last Mowbray.
Raise your right hand for me, please. Do you swear affirm testimony you give in this matter will be the truth, the whole truth, and nothing but the truth? Thank you much. Come up here, please. Have a seat in the black chair that's closest to me. Mary Ann is taking down your testimony. If she can't hear you, I'll ask you to either raise your voice or pull the microphone closer, okay? Thank you. Your witness.
Thank you. Can you please tell the court where you're currently employed?
Van Buren Township Police Department,
And how long have you been a police officer?
approximately 5.5 years at Van Buren Township Police Department, and then 4 years in Roswell, New Mexico.
What is your position with the Van Buren Police Department?
Patrol Division,
And what do your duties consist of in the patrol division?
responding to calls citizens have, such as domestic violence calls, family troubles, civil issues, as well as being proactive conducting traffic enforcement.
Do you have a shift that you usually work?
Yes,
And what shift is that?
night shift,
What time is that usually?
6 p.m. to 6 a.m.
And when you work patrol, are you in uniform?
Yes,
And what kind of uniform is that?
Class B uniform, which consists of an open badge, left side of my chest with Van Buren police patches on either arm.
And do you have body cam on that uniform?
Yes,
Were you working your night shift on July 5th, 2022?
yes,
And did you have an occasion to go to 149 South Ponderosa Trail in Van Buren Township, Wayne County?
yes.
Do you remember what the nature of that call or why you were called to go there?
There were actually 2 incidents. The first incident, it was for a disorderly subject family trouble.
So when you initially arrived, you said the first incident, do you recall what time that was?
Approximately 6:30 p.m.
So that was at the beginning of your shift?
Yes,
Okay. When you arrived to that residence, what did you observe?
made contact with the calling party, identified as Rachel Resler. She advised that her now ex-boyfriend of 17 years that she had been separated with for approximately 2 months had come to the residence, requested to use the restroom. And in that time, she allowed him, male subject, which is Jerome Curtis. She allowed him to use the restroom and advised him that he was not a resident there, he was not allowed to stay, however, he could use the restroom. After he was finished using the restroom, he refused to leave, to which she advised him that he needed to leave, and he refused to do so, so she contacted the police to have him removed.
Okay, and so when you arrived, was Mr. Curtis present
Yes.
the first time?
Yes.
Okay, and so did you make contact with Mr. Curtis?
Yes.
What or how was your contact with him?
Once in the residence, I observed Jerome Curtis sitting on the couch inside the living room of the residence. I asked him if he could stand up, step outside and speak with me, reference the incident, which he complied and did. And once outside, I advised him the reason for conflict.
And what was your conversation like with Mr. Jerome, Mr. Curtis? Did he make any acknowledgements to you about why he was there?
Yes, after explaining the reason why I was making contact with him, reference Rachel advising that he was no longer a resident there and that she wanted him removed because he was refusing to do so. After advising him that, Jerome Curtis acknowledged that he knew he was no longer a resident at the address and that he did not reside there. I advised Jerome Curtis, based on his statements and Rachel's statements, that he was not a resident at the address. I then advised Jerome Curtis reference Rachel's request to have him be removed from the property, and per her request, not to return to her residence and or property.
Okay, and so what did you do once you had that conversation with Mr. Curtis?
Will you repeat that?
What did you do once you had that conversation with Mr. Curtis?
After that-
Did he comply?
Yes, he collected several items from outside the residence and then began walking down Ponderosa Trail.
Okay, how long did you remain at that residence after you saw him walk away?
Short amount of time, maybe a couple minutes.
Okay, but it was to your understanding that he had left.
Yes,
Okay. So, you mentioned first incident. Did you respond again for a second incident?
yes, I did.
Okay, and when was that?
May I refer to my report to the correct time?
Yes, if that will recollect your memory.
It was shortly thereafter, no specific time.
Okay, so you remember shortly thereafter coming back to that same residence?
Yes,
And what was the nature of that call that you were called back there?
that one was for a domestic violence in progress.
When you returned to that residence, was Mr. Curtis on scene at that time?
No,
Okay, and was Miss Resler present?
yes,
Were you able to observe any injuries on her when you made contact with her?
yes.
And what were your observations?
She had a red abrasion on the left side of her torso. She had what appeared to be a red scratch mark on her left clavicle and a red scratch mark on the left side of her face.
Were you able to make an arrest of Mr. Curtis at that time when you responded to, for the second incident?
No, not at that time.
Okay, at what point, or at some point, did you make an arrest of Mr.
Yes,
Curtis?
I did.
And when was that?
I don't know the exact time, but still that night. It
That-
wasn't very long after that call.
Was it near the same residence or elsewhere?
Near the residence.
Okay. And what kind of residence is this?
Mobile home.
Okay, I have no further questions for this witness.
Thank you. Ms. Richards.
Yeah, so briefly. Officer Mulberry, just real quick, you said you aren't sure what time you returned the second time, but you believe it was shortly thereafter.
Yes.
Can you estimate about how long
No.
passed? No? Hour?
No.
You were wearing body cam though, correct?
Yes.
Do you know if the timestamps on your body cam would be correct?
Should be, yes.
Okay. When you ended up arresting Mr. Curtis, did you have your body cam activated when you made that arrest?
I believe so, yes.
I have nothing further. Thank you.
Thank you. Any redirect?
No, Judge, thank you.
Officer Marlbert, thank you for your testimony. Step down. Your next witness?
Judge, the people have no other witnesses.
Any witnesses, Ms. Richards?
No, Your Honor.
Argument, ma'am.
Your Honor, Jerome Curtis is charged with 2 counts. One is the felony for the purpose of this preliminary exam, the home invasion first degree. The misdemeanor count domestic violence would carry over with the home invasion. However, one of the elements for home invasion first is that some sort of assault occurred or was committed when the defendant or when the suspect entered the home. And so here we have an incident where a couple that is no longer together, the testimony indicated that the complainant stated as of at least May 30th or Memorial Day of this year, Mr. Curtis was not allowed to return to that residence. She did not want him there anymore. She had requested that she had requested that he leave the residence. He in fact did remove most of his possessions or his valuables from that residence. He no longer had a key, and he was not there for at least a little bit over a month when this incident occurred on July 5th. He returned to the home on July 5th. Initially, she allowed him to come in for a very brief request to use the restroom. Then she felt uncomfortable and she requested for him to leave. The police even came. The testimony was that the officer told Mr. Curtis that he was not allowed to be there. Mr. Curtis acknowledged to the officer that he was not a resident at that address, that he should not have been there, and he was asked to leave. He left. Unfortunately, he came back, and that's when the assault occurred. The second incident, as stated in the testimony, the complainant indicates that she cracked the door, or there was some sort of conversation that happened first. She cracked the door open to slide him the cigarettes, and then at which point he, in her words, forced himself in. He pushed the door where she couldn't keep it closed anymore, I believe was what the testimony was. At first, even put his leg or body in between the door and then pushed his way in. Once he was in the living room, a physical assault occurred, thereby satisfying all of the elements for home invasion, indicating that Mr. Curtis entered into some sort of dwelling by breaking in. Breaking in is using some sort of force. That he did in fact enter that residence, and when he entered that residence, he committed the crime of an assault. The assault is any sort of unwanted, offensive, harmful touching, which based on the testimony that was given, all of those are satisfied. He was hitting her and punching her with his fists. She sustained various bruises, abrasions, and scratches on her body from that assault. She was on the phone with 911 during the entirety of that assault. And therefore, all of the elements for home invasion first are met for probable cause standards, and therefore we respectfully request that the court bind over the defendant on the charges set forth in the complaint. Thank you.
Thank you. Anything else, Ms. Moisesian?
No, that is all. Thank you.
Court has had the opportunity to hear the testimony of both Ms. Rachel Resler and Officer Curtis Maubrey, and we'll find that the people have met their burden for count one in this matter, home invasion first degree. The misdemeanor travels along with it. The next date in these proceedings will be an arraignment on the information, which will be on October 12th, 2022 at 9 a.m. Mr. Curtis's previously entered bond with any conditions will continue. Anything else on behalf of the people?
No, thank you, Your Honor.
Anything else, Ms. Richards?
Your Honor, I'd ask that the court consider ordering a DSU report for the next hearing.
I've written that in the file. I'll make sure the clerk addresses that, but anything else, Ms. Richards? I wanted to recall that other matter 220-628 FY because I thought we set the PCC date on next Wednesday, the 12th.
Yes.
And if he's 10:50 with here, will he be done with his AOI at 9 o'clock from Frank Murphy?
That's a good question.
And I'm wondering if the PCC for the receiving concealing from July 26th should be put over until maybe October the 19th?
That would be fine.
Okay. Marianne will get a time if you give me one moment. At 10 o'clock. Who is that? Oakley? I don't keep track of it.
Your Honor, actually, in front of Judge Oakley, I might not be able to do that date.
If Mr. Curtis is still in custody, will that change? That would be by. Well, he's at 10 a.m. because he's personal in the case that would be with Judge Oakley, but we know that he'll be in custody because I can't imagine DSU. I think I understand your quandary, but for our purposes, because he is in custody.
It would be an in-person PCC or
give me one moment because Mr. Curtis is in custody, we typically would set it on the 8:30 docket and ask Heather if we should. Thank you. We should put him on the 8:30. So on October the 19th, it will be at 8:30 Zoom with Judge Oakley, courtroom number 2. As soon as I said the AOI did, I knew it would be a problem. Anything else, Ms. Richards?
No, Your Honor, thank you.
Anything on behalf of the people?
No, thank you, Your Honor.
Thank you. That concludes this matter. Officers will take Mr. Curtis. Officer Marbury, do you have a moment on a completely unrelated matter? And then if you will get the status of the last exam, I think that's with Ms. Bailey. Yeah, so I can get it signed and get him on his way.
Hopefully not soon, that's back to back to me this week.
No, stay seated. She went to get the writ for the previous case. So we don't have a reporter yet. This is 192004 FY, State of Michigan versus Shania Nelson. Shania, thank you.
Good afternoon, Your Honor. Bryn Bailey on behalf of the people, P84009. Good afternoon, Your Honor. May we the defender service record shop the person on behalf of Ms. Nelson, P84015.
And state your name for me, ma'am. Shania Nelson. Thank you. Today is the day and time set for the preliminary examination. In this case, there is count one, possession of narcotic or cocaine less than 25 grams. Are the people ready to proceed?
Yes, Your Honor.
Defense ready to proceed?
Yes, Your Honor.
Any preliminary matters, ma'am?
None from the people.
Any preliminary matters, ma'am?
None, Your Honor.
Your first witness, Ms. Bailey.
Your Honor, at this time, we'll call Officer Sarah Zaglonis.
Stop right there at the podium for me, please. Say your first and last name and then spell them for the record. Raise your right hand. Do you swear affirm testimony you're giving this matter will be the truth, the whole truth, and nothing but the truth? Thank you much. Come up here, please. Have a seat in the black chair that's closest to me. Mary Ann is taking down your testimony. For some reason, she can't hear you. I ask you to either raise your voice or pull the microphone closer. You're a witness, ma'am.
Thank you. Officer Zaglonis, how are you currently employed?
As a police officer in the city of Belleville,
How long have you been a police officer with Belleville?
5.5 years.
Were you employed and working for the Belleville Police Department on January 18th, 2019?
I was.
And were you by yourself or with a partner on that day?
I was by myself.
Were you in a scout car or on foot?
I was in a fully marked patrol car.
Officer, if you pull, I'm sorry, pull the microphone closer towards you. Thank you.
Do you need me to have her repeat any of the questions? Okay. Okay, all right. You said it was fully marked?
Yes, ma'am.
What about your clothing? Were you in full or modified uniform?
Full department issued uniform.
What does that look like?
BDUs, auto carry vest, full belt, cargo pockets, boots,
Your
lots of
name,
insignia on the sides, the patches, the word police across the back, my name across the front.
all right, excellent, thank you. Did your duties as a Belleville police officer take you to High Street near Belleville Road?
Those two don't intersect.
I'm sorry, I'm trying to strike that. Did you have occasion to go to High Street in Belleville on that day?
Yes.
Why were you there?
I was enacting a traffic stop.
And why were you enacting a traffic stop?
I observed a vehicle travel through the right turn lane and used it as a through lane.
And would it, so instead of turning right in a right turn only, this, you observed the vehicle drive straight through the intersection?
Correct.
Okay. And do you recall what kind of vehicle?
It was a Malibu, Chevrolet.
And so you observed this and you initiated a traffic stop.
Correct.
Did the vehicle stop?
It did.
And what, if anything, did you do after the vehicle came to a stop?
I made contact with the driver first.
Was the driver the only occupant?
It was not.
How many other people aside from the driver were in the vehicle?
One other person.
Do you see either the driver or the occupant here in the courtroom?
Yes, the passengers sitting right here.
Okay, so what is she wearing? What is this person wearing?
The passenger that was in the vehicle is wearing a sweater that's predominantly white with black accents.
Your Honor, let the record reflect that the witness has identified the defendant.
Yes, ma'am.
So you stated that the defendant was a passenger, front seat or back seat?
Front seat.
And so you made contact with the driver.
Correct.
And what, if anything, did you do after making contact with the driver?
I requested his driver's license, the vehicle's insurance and registration, informed him of the infraction.
Was the driver able to provide you any of those documents?
He gave me an ID card, so no.
So after obtaining the ID card from the driver, what if anything did you do next?
I asked about the other documents and he stated it wasn't his car. And then the passenger piped up and said it was her car.
And what if anything did you do after hearing the defendant say that?
I asked her if she had any of the documents. And she told me that she did not have insurance and provided a registration certificate.
And what if anything did you do? Did you ask her for an ID?
Not at
Or a
that point.
driver's license?
Not at
Okay.
that point.
So after obtaining the registration and the ID from the driver, the registration from the passenger, the ID from the driver, what if anything did you do next?
I asked the driver if he had a valid driver's license. He stated he did not. So at that time, I asked the passenger for a driver's license.
And did she provide you with a driver's license?
Not at that time.
Do you know why she didn't provide you a driver's license?
I believe she said,
Objection, Your Honor, speculation. Testify to why the bank does or did or did not.
Well, Your Honor, if the defendant told her why she didn't have a driver's license to produce, then that's not speculation.
I don't think that was the question, though. The question was, do you know why Ms. Nelson didn't produce a driver's license? I thought that was the question.
I'll rephrase.
I was gonna say the objection sustained, you might want to get your information a different way.
So you indicated that the defendant did not provide you a driver's license at that time. What do you mean by that?
she did not hand me a driver's license when I asked for one.
Did she ever give you a driver's license?
She did not give it to me. I did locate one though.
You located one?
Correct.
Where did you locate it?
Inside the vehicle.
Did she provide you with her name?
She did.
Okay. And what, if anything, did you do after obtaining this information?
I ran both the driver and the passenger through Lean and SOS.
And what, if anything, came back on the defendant, Miss Nelson, from Lean and SOS?
She returned with some warrants for traffic violations and suspended license.
And what, if anything, did you do after gaining this information?
After that, another officer arrived on scene to assist, a male officer, and he took the driver into custody for driving a suspended license. And then I dealt with the passenger, the female defendant.
And when you say dealt with her, what do you mean by dealt with her?
I advised her of her warrants and removed her from the vehicle.
Why did you remove her from the vehicle?
I was impounding the vehicle for the driving infraction. And I was informing her of her warrants as well.
Were you placing her under arrest at that point?
Not at that time.
So you asked her out of the vehicle because you're going to impound the car for what? No insurance, neither of the drivers having.
Nobody could drive it.
Okay.
Correct.
Thank you. So what, if anything, did you do after asking the defendant to step out of the vehicle?
I asked her out of the vehicle and I observed she appeared to be pregnant. And I asked her if she was pregnant. She stated she was approximately 6 months pregnant. So at that point, I did not put her in handcuffs out of courtesy for her. But I just asked common questions. I said, do you have anything on you that's illegal or dangerous? I could, hurt me, poke me, stick me. And at
What,
that,
if anything, did she say in response to that?
at that point, she said, I just have marijuana. Well, I think she called it weed on me.
Okay. And did she inform you where that was?
Yes.
And what, if anything, did you do after finding out where this, I'm going to use air quotes here, weed was?
I asked her to hand it over to me because it wasn't illegal, but she couldn't keep it with her while she was with me.
Okay. And where did she pull it from?
She pulled it out of her bra.
And did you take possession of it?
Yes, she handed it to me.
Okay. And what, if anything, did you observe about this, what she called weed, when she handed it over to you?
It was white, powdery substance in a plastic bag.
Clear plastic bag?
Yes.
What, if anything, did you do after observing this white powdery substance?
I asked her, I said, what is this? This doesn't look like weed.
And what, if anything, did she say?
She said she didn't know.
What did you do next?
I asked her where she got it from.
And what did she say anything about that?
She stated she didn't know.
Okay. What did you do next?
I put it in an evidence bag and put her in the back seat of my patrol car.
What if anything did you do after placing the defendant in the backseat of your patrol car?
Advise her that she's under arrest for possession of suspected narcotics.
And then what?
She was booked and processed accordingly.
And did you, so prior to impounding a vehicle, is an inventory search conducted?
Yes,
Did you conduct an inventory search in this case?
yes.
Aside from the driver's license that you testified about earlier, did you find anything else of note during this inventory search?
Nothing, no contraband.
So, do you recall, let's talk about the suspected narcotics.
Yes,
Did you place the suspected narcotics onto evidence?
I did.
Do you recall the evidence tag number?
I do not. They're probably a 10-digit number.
Would you have put that in your report?
Yes,
Would reviewing your report refresh your recollection?
yes. I know it starts with a 19. And it ends with a 001.
Let the record reflect that I am showing several pages of a report.
Yes.
I'm gonna direct your attention to the last page, where I believe that the contraband is listed. Is that a report that is generated by you and or your office?
Yes.
Please review that silently to yourself and look up it when you're done. Does that refresh your recollection?
Yes, ma'am.
What was the evidence tag number for this case, or for this suspected narcotics?
190000264.066.
So it's placed onto evidence.
Yep.
What, if anything, do you do with it after it's placed onto evidence?
Secured in a property locker at our station.
And do you know what happens to the narcotics after it's secured in the property locker?
Yes.
What?
The chief of police retrieves it and drives it to the Michigan State Police Lab.
And in this case, did you receive laboratory results back?
I did.
Would you recognize those laboratory results if I showed them to you?
Yes.
Permission to approach?
Yes, ma'am.
Officer, what have I just handed you?
The Forensic Science Division laboratory report from Michigan State Police.
Is it a fair and accurate representation of the lab report that you received back?
Yes.
Has anything been changed or altered?
No.
Is there an evidence number listed there?
Yes.
Can you please read it into the record?
It's item number #66.
And do you see the rest of the evidence tag number listed anywhere?
No. The 190264.
And is that the 19-0624? That would be the evidence tag number and the case number, but with all of the zeros removed. correct?
Correct, yes.
Okay. Your Honor, at this time, people would move for the admission of the people's proposed one.
It'll be received. Thank you.
And Your Honor, with that, people would move to publish the people's one.
Yes,
And
ma'am.
no further questions.
Ms. Kirkland, your witness.
Thank you. Good afternoon, officer. Can you pronounce your name for me just one time?
Zagalonis.
Zagalonis. Okay, thank you. So Officer Zagalonis, you testified today that you first approached the driver's side of the vehicle, correct?
Correct. Yes,
And you
ma'am.
first made contact with the driver of the vehicle.
Yes, ma'am.
And eventually you made contact with the passenger, who was Miss Nelson.
Correct.
Okay. Now, I want to take you to when you pulled Miss Nelson out of the vehicle.
Yes, ma'am.
You requested that she get out of the vehicle because you were going to tow that vehicle.
Correct.
And at that time, she was not under arrest.
Correct.
Now, you asked Miss Nelson if she had anything illegal on her person, correct?
Illegal or dangerous.
Illegal or dangerous. And she responded that the only thing she had on her was marijuana.
Correct.
And then she proceeded to hand to you what she believes to be marijuana.
Yes, ma'am.
Do you remember what the expression on Miss Nelson's face was when she handed you, or when, I'll back it up. So she handed you what she believed to be the marijuana, correct?
Correct.
And after that, you looked at the substance and saw that it was white
Correct.
and that it probably was not marijuana.
Correct.
What did you say to her after that?
I asked her what it was.
Now, do you remember what Miss Nelson's reaction was when it was learned that that was not marijuana?
Yes.
What was her reaction?
She appeared to be surprised or in disbelief.
Okay. Now, I want to fast forward a little bit. Miss Nelson was eventually arrested.
Correct.
She was put in the back of the patrol vehicle.
Yes.
She was taken to the station.
Correct.
You all allowed for her to keep her phone on her.
Correct.
And there was a point where she made a phone call to her mother.
Correct.
And during that phone call, you heard the conversation? Were you there to hear the conversation?
Yes.
And during that conversation, you heard her say that the driver of the vehicle had handed her something that she believes to be marijuana, correct?
Correct.
So from Ms. Nelson's representation, she had every belief that that bag was in her bra was marijuana.
Objection calls for speculation.
Can't remember the wording of my question, but I can reword it. Ms. Nelson only represented that that bag was, let me rephrase. During the entirety of your interactions with Ms. Nelson, she had always represented that her belief was that that bag was marijuana.
Yes, that's true.
And in fact, it was even written in the report that those narcotics possibly belong to the driver of that vehicle.
Yes, it was written in the report.
I don't have any other questions. Thank you.
Thank you. Any redirect?
When she handed it to you,
Yes.
actually, no, strike that. How long have you've been an officer for what, 8 years?
Yes.
Have you ever seen marijuana that was powdery or white?
No.
And the bag that she handed you was clear.
Correct.
And it was apparent to you when she handed it over that it was a white powdery substance, not something dark green and leafy.
Correct.
No further questions.
Thank you. Officer Zagalonis, you may step down. Thank you for your testimony. Your next witness?
No further witnesses.
Any witnesses, Ms. Kirkland?
None, Your Honor.
Argument as soon as the officer clears the wheel.
Your Honor, at this time that people move for a bind over. The defendant readily handed over what is tested positive now for cocaine, as evidenced by the People's One, indicating that it was in her bra. She knew she was in possession of it. I think it's a question of fact as to whether or not she reasonably knew what it was or not. Given the stark difference between what marijuana looks like and what she handed over, I think that it is a question of fact for a trier of fact that she didn't know. She knew she was holding it, she admitted she was holding it, and she immediately turned it over, Your Honor, that it's tested positive for cocaine. People move for bind over on the count one as charged.
Ms. Kirkland.
Thank you, Your Honor. Defense should object to the bind over. So one of the elements of possession of a controlled substance, the very second element is knowledge that that person possessed a controlled substance. It's not knowledge that they reasonably believe that they possessed it or had reason to know or should have known. The language is knowledge that they possess a controlled substance. In this case, the officer testified that Ms. Nelson, when she handed over, before even handing over the substance, said that she had marijuana in her bra, and that when she handed it over, she appeared shocked and in disbelief, to use the officer's exact words, to learn that it was not that. After that, they heard a conversation between Ms. Nelson and her mother, who was on the phone, where Ms. Nelson explained that she was handed something and told to hold on to something, and that that her belief was that it was marijuana. Marijuana, as the officer testified, she told Ms. Nelson, was legalized at that time, and it's still a legal substance. Hereby, like her possessing that marijuana in her bra wouldn't have violated her law. Wouldn't have violated any law in Michigan, Your Honor. So Ms. Nelson did not know. She did not know that she was in possession of an illegal controlled substance, and an element of this crime is knowledge that she possessed, or knew that she possessed a controlled substance, not reasonable knowledge, as Ms. Bailey said she has proven today. She has not proven today at a probable cause standard that the defendant had not. So we object to that over.
So, if I may, Your Honor,
Absolutely.
marijuana is legal. It has been. Why would she need to hold onto a completely legal substance for somebody during a traffic stop? That doesn't make sense, Your Honor. Looking at it, you could tell by this officer's testimony, it didn't look like marijuana. Asking someone to hold on to a completely legal substance isn't something that happens, Your Honor, especially it's legal. You don't ask someone to hold on to a completely legal substance if it's legal. I know that I'm using a lot of. The people would put forward that it's a question of fact as to whether or not she actually knew. I put forward to Your Honor that she did actually know, because one, the substance is so far diverted from what marijuana looks like, and two, common sense would tell us that legal substances aren't requested to be hidden by someone during a traffic stop. So I think that the people have met their burden and created and established a question of fact, and I would ask that this court find over.
Your Honor, if I just-
Absolutely.
Okay, just briefly, the testimony wasn't that the driver requested that she hide it. The testimony was that the driver asked, and the Lansing police report was that the driver asked that she hold on to something. And when people know that they're going to get arrested, as we've learned today, the driver would have warrants. People ask, passengers to hold on to phones, to different things that they know will be stuck in custody. I don't want to go down that rabbit hole, but I don't think that's necessarily common sense that you don't have people hold on to things that are legal. And there's also put forth no evidence that Ms. Nelson saw the substance prior to concealing it in her bra. So
That she
ever saw. Ms.
saw,
Bailey, yes,
okay.
Ms. Bailey is she's saying that there's clearly a difference in the color of marijuana and cocaine, which I
So that's just a misstatement of the facts by Ms. Kirkland.
I do believe that the driver did have warrants, but even if the driver didn't have warrants, the driver had a suspended license. The driver knew that they were.
Last word, Ms. Bailey.
Just, Your Honor, there was one, Ms. Kirkland stated facts that weren't in evidence. There was no testimony as to whether or not the defendant, or the driver, I apologize, the driver had warrants. So that's assuming a fact, not in evidence here today. And, Your Honor, she was handed something and stuffed it in her bra, which is an attempt to concealment. She knew it was there, and I think the people had met the burden.
The court's memory of what Officer Zagalona said was that the defendant had warrants, and either, I don't know if I misheard it, but that appeared to be what the testimony was. That's a side note more than anything else. The fact that there's this presumption that somebody would know the difference between marijuana and cocaine just assumes a level of exposure to drugs that I guess is incident to our profession. Again, that's an aside. More than anything else, the court has heard the testimony of Officer Zagalonis and reviewed the report from Michigan State Police that puts the weight at 1.57 grams of cocaine from evidence item number 66 that was turned over by the Belleville Police. We'll find that the people have met their burden for the probable cause, their probable cause burden for this preliminary examination. Will bind Ms. Nelson over as charged. The next date in these proceedings will be their arraignment on the information, which is on October 19, 2022 at 9 a.m. The bond is currently 10,000 personal and will continue. Anything else from the people?
Nothing further from the people.
Anything else, Ms. Kirkland?
Nothing, Your Honor.
Thank you. That concludes the matter for this afternoon. Ms. Bailey, you have a 3:15.
Yes, ma'am. I believe I resolved it and provided the files.
I just was going to leave the Zoom up, but if you've already talked to your other party, we'll take the Zoom down. That concludes this matter. This court is adjourned. Thank you. I have to show you something. Make you laugh. Nope, I'm coming to show you.